extend this warm welcome to you for Judging and Lawyering at the Margins, a collaborative initiative between Sugandha Bhandare Foundation and QAble. We are especially glad to see so many members of the bar and the bench here. I would formally like to invite Justice Manmohan, Justice Lokar, and Justice A.K. Sikri to initiate the lighting of the lamp. Yes, of course, Anchal. Thank you for marking the beginning of today's important dialogue. Your presence speaks volume to the shared belief that justice must be inclusive, accessible, and grounded in lived realities. I now invite Ms. Shreya Singhal to deliver the welcome address. I would now like to request the panelists from the first panel, moderated by Amar, to kindly join us on the stage.
Good morning, everyone. May I first request everyone to please put your phones and tablets on silent. Uh, and as an extra thank you for coming here on a Saturday morning so early, especially our panelists who have come for the next sessions a little earlier to enjoy this session. So thank you very much. Justice Manmohan, Justice Sikri, Mr. Rahul Bajaj, Mr. Praveen Prakash Ambasta. I welcome you all to the seminar Judging and Lawyering at the Margins. The issue of accessibility to the courts was very close to my grandfather's heart. During his career, he took up and made this issue his own. Under his vision for equality, the Justice Sunanda Bhandari Foundation filed a public interest litigation before the Honorable Supreme Court of India for the implementation of the Persons with Disabilities Act 2016. The Honorable Supreme Court of India was pleased to pass directions for its implementation by all state and union territories in letter and spirit and continues to monitor this till today. Queable is a community-led initiative founded by Achal S. Bhatija, focused on foregrounding the intersections of queerness and disability in law and public policy. Queable works through capacity building, sensitization, training, awareness campaigns, strategic advocacy, and community outreach. It aims to make legal, education, and institutional spaces more inclusive, accessible, and affirming for disabled and queer individuals. In today's day and age where accessibility has come into the foreground and not on the fringes and in the background, both the Justice Bhandari Foundation, Sunanda Bhandari Foundation, and Queable today welcome all of you in this discourse so that we can move forward and not leave this in the fringes and bring it to its rightful conclusion to give inclusivity to everyone every day. Last but not least, I welcome you all, students, teachers, lawyers, media persons, and volunteers whose unstinted support has encouraged and motivated us to carry forward the work that both the Justice Sunanda Bhandari Foundation and Queable have started. Thank you so much.
Should I take over? Okay, sure. Good morning, everyone, and thank you for joining us on this Saturday morning. We are going to talk to STEAM panelists, and I'm going to introduce one by one. To my left, I'm joined by Honorable Justice Sikri, former Judge of Supreme Court, and I'm proud to say he is a patron and chief of Mission Accessibility. He time and again guides us, mentors us on strategy when it comes to disability rights litigation. Then I'm joined by Justice Manmohan, sitting Judge of Supreme Court. I've had the pleasure of appearing before Justice Manmohan when he was acting Chief Justice of Delhi High Court. He's been very pointed in his questions, I must say, and someone who passionately drove the cause of persons with disabilities when I had the pleasure of appearing before him in Delhi High Court, be it access to currency and financial inclusion, and be it even animal menace matter, where Justice Manmohan remarked when Rahul was arguing that this blind man has a right to walk on the street, and it was very affirmative to see this coming from a judge like him back then. So pleased to have you here, sir. Next to Justice Manmohan, I have Praveen Prakash Ambasta, sir. He is a Deputy Chief Commissioner for Persons with Disabilities at the Court of Chief Commissioner for Persons with Disabilities. Someone who has really driven the cause of disability with passion, understanding of law, and lived, connecting with users who have lived experiences of being persons with disabilities. So thank you for joining us, sir, today. And next to him is my co-founder, my partner in crime, Rahul Bajaj, co-founder at Mission Accessibility and also partner at Zen Access Law Associates, a law firm that is led by persons with disabilities but not limited by disability. Rahul is someone, I know him since 2010, I think, and he's someone who has really, in a very short span of time, ever since he began formally his career in disability rights litigation, apart from being a mainstream professional, has earned a huge respect in minds of clients, in minds of people, legal fraternity, and in minds of judges alike. Everybody wants today Rahul Bajaj on a specific matter whenever there is a complex question of law involved. So pleased to have everybody here. Uh, so when we think of judging and lawyering from a disabilities perspective, and especially from clients with disabilities perspective, there are a lot of things that come to my mind. I'll just set some context. Just to introduce myself, I'm I'm Amar Jain. I'm a corporate lawyer and an accessibility professional. I have worked with Trilegal and Sir Namalchand Mangaldas in banking and finance and capital markets. And now I lead, along with Rahul, Mission Accessibility as well as an Access Law Associates. That's a very basic about me. Uh, when it comes to talking about lawyering for persons with disabilities who may be clients, there are a lot of challenges. Sometimes those challenges could be awareness of what the law can provide you, which forum to approach, the financial aspects, the competent legal representation, to find competent lawyers who can represent your case, to ask for reasonable accommodations and accessibility, to make sure that the judges who are judging your case understand not just the law but also the fine lived realities of persons with disabilities and the practical challenges that poses. So sometimes you have to really read between what the law and policy provides versus what the lived reality is to be able to deliver justice. So my first question would be actually to Rahul. Rahul, you have really spot on the cause of persons with, you have really delivered spot on when it comes to causes of persons with disabilities. You have led many litigations where you have really gotten extremely good outcomes, not for the individual case concerned, but even for the strategy, for policy building, and for building the entire ecosystem of justice and the idea of justice for persons with disabilities. My first question to you would be, what, in your opinion, should be done to build institutional capacity or to bring institutional reforms so that clients with disabilities are able to avail accessible justice in its true and inclusive manner?
Yes. Thank you very much, Amar, for that very kind introduction. And it's an honor to share this stage with Justices Sikri, Manmohan, and Mr. Ambasta. Justice Lokur is also here in the audience. So thank you very much for being here, and I commend QAble and the Sunanda Bhandare Foundation for taking an important step in bringing this issue to the mainstream and kind of repositioning it from the margins, as it were. So to answer your question kind of squarely, at Mission Accessibility, as you are aware, we've really taken up the cause of providing legal aid to persons with disabilities at scale. So just to kind of provide a few figures, right? As of now, we have about 44 cases which are ongoing in different courts and tribunals across India on behalf of persons with disabilities, many of which are on a pro bono basis. And we take up 3 pro bono cases every month on behalf of persons with disabilities, because as you are aware, there is a strong linkage between disability and poverty, and therefore it becomes important to figure out how to provide competent legal aid at scale to such persons, but in a manner which is also sustainable for us as an organization. And a few things that we've kind of been able to do till now, because one thing I should just say as a prefatory remark is that often you will see lawyers who are doing disability rights cases on the side. They might do 1 or 2 cases, but their main practice area is something different. For us, that is not how it is. As of now, as things stand, disability rights is our main practice area, which is why this issue of institutional support becomes important. So what I was saying is that until now, the way we've managed to make this sustainable is through some support from senior lawyers, retired judges, and so on. But going forward, this is something which requires institutional attention, and there are 3 kind of specific suggestions that I have to give in terms of how do we make this litigation and this kind of legal aid possible from a funding and institutional support perspective? First, I think the legal aid authorities have an important role to play here, because as you are aware, persons with disabilities are a class of beneficiaries recognized under the Legal Services Authorities Act. So one good measure which the Delhi High Court has taken in this direction is to empanel lawyers with disabilities on the Delhi High Court Legal Services Committee, so that when cases of such persons reach the committee and there are lawyers with disabilities, so they can, not to say that it should only be given to such lawyers, but they can definitely be considered given their lived experience and expertise in the area. And that also takes care of the funding gap, in the sense that the legal services committee is able to step in, but the litigant obviously can't afford, and the lawyer also needs a form of sustenance. So that is one measure which I think even at the level of the Supreme Court may be considered, and that could be an important step. The second is, from a CSR and CSR and foundations run away from supporting this kind of work, because advocacy is somehow seen not through a very positive lens. Although I personally believe that it is very required to translate the letter of the law into practical outcomes for people with disabilities, but that culture change has to come in terms of making CSR donors and foundations recognize that this kind of work is also worth supporting. And the third is providing more conventional opportunities to lawyers with disabilities, because people tend to then box you in as a lawyer who's only good for disability rights, or who can only do this kind of work. So getting opportunities, conventional legal opportunities alongside your disability rights work is also important from a sustainability perspective.
Thank you, Rahul, for those insightful remarks to begin with. I'll come back to you with a couple of more questions in due course. I'll now move on to Praveen Prakash Ambasta, sir, who has been manning the post of Deputy CCPD at the Chief Commissioner's Persons with Disabilities at the office. Sir, in your experience, what kind of cases do you see mostly coming in? And what level of support from the law, from the path-breaking judgments that Supreme Courts or High Courts keep delivering from time to time on disability rights matter, do you draw upon? And what do you see which can support stronger implementation of orders passed by your Honorable Commission or the State Commissioners? I know it's too many questions in one question, but I want to make the most of the time that we have at hand.
Thank you, Advocate Amar. Thank you. And thanks to the organizers for inviting me over here, giving an opportunity to the CCPD office to voice its opinion through me. And I mean, one is overwhelmed sitting beside the honorable judges here. I know that that's not my place to be here, but with due respect, sir, I would answer there are three queries that you made, Amar. One is what kind of cases do we receive? So only yesterday we were preparing for a parliament question and studied the last 4 years data, and out of total cases that we receive, almost 25% of the cases are one on, and only ground is that transfer requests from one city to another city. These are employees of various central government departments and public sector undertakings, insurance companies, banks. They want either their transfer order to be revoked or transferred to a place of their choice, which is definitely covered in the Act in Section 20 and 21. But it is, I mean, the numbers are quite huge, and other matters, service matters, are more than that actually. Around, if you club transfer and service matter, they go beyond 55 to 60%. Which means what? Which means that people who are educated, people who can actually afford, they are coming to the CCPD office. But issues related to accessibility, I was absolutely amazed to see that in 2022 we got just 7 complaints on accessibility. 2023 it got increased to almost 79, but 70 of them were filed by either Amar Jain or Rahul Bajaj. So yeah, so one odd case filed by some other person where you were the lawyer grows, So 71 out of 79 cases, courtesy you in the CCPD office, But accessibility has now taken up. 23, 24, we are getting more cases on accessibility and particularly on digital accessibility. And that answers to your second question, what kind of support are we getting? Absolutely, there is no denying the fact that when the CCPD sits in, the hearing, and he draws strength from the one Rajiv Raturi judgment, then Pragya Prasoon and Amar Jain judgment, then very recently another judgment has come in May, Raj Sekharan versus Union of India on barrier-free pavements, right to clear footpath. So when these judgments come, they do help us because we do not have any power of our own other than the mandate in the Act and the judgments which have come from the Supreme Court and High Court. So definitely these judgments do come in to help us in issuing a reasoned order. And when the orders are reasoned, it translates into good compliance. There is one PIL right now before the Honorable Supreme Court, Dr. Satyendra Singh versus Union of India. Without going much in the detail, but that PIL is trying to convey that CCPD and SCPT as toothless tigers and they have no powers and therefore there is no compliance. But let me tell you here that in almost 30 to 40% cases every year, we get compliance even before hearing. So just by issue of a reasoned notice, even in our notice, we try to put forth all the arguments in whatever legal framework, and so therefore we are getting compliance even just by issuing the notice. And in remaining also, yes, definitely there is a cause of concern when the government departments do not get back whether they are accepting the recommendations or they have a reason to reject the recommendation. That is a cause of concern. We are working towards it. But with the help that we are getting from the judiciary, I am very, very hopeful that we will be much more effective. And about the kind of support you were saying, no, I'm absolutely not looking for powers beyond executive. We are absolutely aware that we are totally part of executive. And so there is no intention of donning the role of any court. So within the mandate that we have, for which I may specify, it is against establishments for which the central government is the appropriate government. That is the language of the Act. And in accessibility and equal opportunity policy, even private establishments. That is what the jurisdiction we have, in which we will keep working. We would like to have a bigger body which takes into its fold other two organs of the state, but that is for some other day. I mean, right now the Act doesn't provide for that. Thank you very much.
So just a follow-up question before I move on to Justice Manmohan and Justice Sikri. My follow-up question to you would be, sir, don't you think there is a need for having strengthened framework for implementation of recommendations passed? Because right now these are recommendations passed by CCPD, and thanks to the Delhi High Court judgment in Mukesh Kumar versus NTPI matter, where it said that binding recommendations ought to have been complied unless there is a justified reason for non-compliance. And I'll tie in this question with your interface with special courts, because many times we have seen that there are matters in CCPD which are appropriate for adjudication by special court that are set up under Rights of Persons with Disabilities Act because they have an angle of criminality involved. How have you seen when you have either referred a matter to special court for their consideration, whether those matters have been effectively taken up, or would you have any thoughts to strengthen that framework as well?
I think this special court system is still, very far from being properly, active. There are two matters which in the last 3 years we have referred, one in the Andhra and another one in Delhi. And our experience has been, with due respect and humility, I would say, that the concerned judge was not aware that the judge is the special court for persons with disabilities. Once they referred it to the district judge, then district judge wrote it back that it is your matter, and then the matter, actually the whole idea of sending it to the special court is to have a speedy trial. But then it got into some other thing that CCPD should file a complaint. There are issues how, being a part of the executive, we can file a complaint in police or before a court of law against another arm of the judiciary, where both organizations will be represented through government councils. So that is one issue we are trying to and in the Andhra matter, what happened is that this is a police brutality matter. Of course, Andhra police is not within the central government control, so we had to refer it to first to the SCPD. When nothing happened, then because the It was a case where a child with disability who was a wheelchair user with 55% disability, in one night she was beaten so much that the disability increased from 55 to 90%. So one hearts bleed what to do in such cases. So therefore we referred the matter to the Chief Justice of Andhra High Court for being taken up. But the pace has not been, in the last 2 years, it has been actually going to be 2 years in September. We have not seen much development in that case. So that is required to be looked into, and I'm sure authorities will take care of that.
Thank you, sir.
If I may
Yes,
be allowed
please.
for one
Yes.
thing about when we're talking about lawyering, I'm saying this because I don't know whether I'll come back or not.
No, you will, sir.
So this
You
one
will
point I really wanted to discuss. In one of the orders of CCPT also it has come. The 1992 judgment of the Indira Sawhney, para 95, the Honorable Supreme Court said that the reservation for persons with disability is not akin to reservation for SC/ST. That reservation is not under 16.4, it comes under 16.1. And we all know that Article 16.1 doesn't even talk about reservation, it talks about equality of opportunity. And so that means there are two things. One is 16.1 talks about employment or appointment. So whereas 16.4 only talks about appointment. So the scope is larger. Here it is talking about employment as well as appointment. The second thing is that it is about equality of opportunity, not increasing the representation of a particular community in the services or the offices of the state. So when we are talking about lawyering at margins, maybe this is a time when we should also take up, at some level, that in the empanelment of senior government councils also, and all other opportunities, including notary and everything, because this reservation is part of employment. So all employment opportunities, including in judiciary, should also be thrown open to persons with disabilities. That's my view, and thank you. Thank you.
I think, sir, quite a powerful recommendation. I'll now move to Justice Manmohan. Lordship, the question that often keeps me wondering, and it's straight coming from the experience of having represented cause of persons with disabilities, both as a lawyer and as a person living with a disability. More often than not, we have seen that courts have passed historic judgments, but the problem remains in implementation. And unless the cases are monitored by the court for compliance, and which is the trend which we have seen recently picking up, where courts are also monitoring compliance of implementation of those judgments, especially when it comes to matters like disability rights, judgments are more often, paralyzed by implementation gaps. What would you say to that, and what could be effective strategies to address that?
First of all, I would like to thank the organizers. I think it's a very important issue on which this seminar has been organized. What is the need of the hour is to create sensitization, to create awareness. And I think the more awareness is there about the act, about the rights that are available, the more the society will understand, the more the courts will understand, and it will ensure more compliance. Coming to the question, yes, you are right. This requires continuous monitoring of a judgment that has been given. But there are huge issues with regard to continuous implementation. First of all is the court dockets are absolutely full. And really to say that court will pick up this issue and give it absolute priority is not feasible, because every day the court is grappling with so many issues. All said and done, I agree with you that a continuous mandamus may be the need of the hour. But keeping in view the constraints that we have to ensure that our other organs of the state also rise to the occasion. The legislature will have to be aware of this issue and will have to put in place some mechanism whereby the court orders are given effect to. It cannot be done at the pain of contempt. Everything cannot be done at the pain of contempt. And if we start using the power of contempt repeatedly, it also loses its utility at some point of time. Therefore, people must understand And the executive must understand that this is an act which has been passed by Parliament, keeping in view its international obligation. This law is in alignment with the United Nations Convention, which the Government of India has ratified. Therefore, we have to ensure that the executive machinery understands that this is an obligation on them, and this is not some charity being done. After all, this is a right of the person. I think the basic problem that is arising is because everyone is believing that this is some sort of a charity which is being done. You think of any concept, whether it's gender justice, whether it is persons with disability, the mindset of the executive, as well as to a large extent the people who have been adjudicating these matters in the past, has been that we will deal with it as if one is doing a bit of a charity. See, this whole ecosystem has to change. The implementation will arise of judgments with regard to persons with disability when the mindset changes, when the mindset of the common man as well as the executive realizes that this is top priority, this must be done. This is the right of a person. And what is this act doing? It is only giving a reasonable accommodation at the end of the day. It is only ensuring that people who are suffering with either mental or physical disability are given a chance to compete. So the whole ecosystem needs to change. And once that ecosystem changes and people realize that it is a rights-based approach and not charity which is being done, then things will change. But yes, I agree with you. As a short-term measure, the court will have to monitor and will have to ensure that its judgments are implemented. And the best way is to keep the matter pending and to pass continuous orders, which will be in the form of continuous mandamus.
Thank you so much, sir, for those insightful remarks. This actually ties in with my next question, which goes to Justice Sikri. So, what sort of reforms, as Justice Manmohan rightly remarked, that the difference between charity and rights really need to be travelled when adjudicating upon causes of persons with disabilities. What, in your opinion, could be the legal reforms, be it through judicial academies or otherwise, could be brought in to make sure that even judges, lawyers, court staff, and other stakeholders of the legal system are made aware of rights of persons with disabilities, the concepts like non-discrimination, the concept like reasonable accommodation, which you pointed out very beautifully in Rajiv Ratiri's judgment as reasonable differentiation before even this term was coined in our act. So what in your view could be those measures?
Thank you, Amar, and I should also thank Sunda Bandare, this foundation, for giving me this chance to be here today and sharing my views. You see, I think you have put a very pertinent question, and I think that's the very foundation of the rights of disabled. As I see the history and over a period of time when, such causes came before me in the High Court and Supreme Court, and I studied about the rights of disabled persons deeply in that context. As I say this, if you see 40, 50 years ago, when the persons who are suffering from various kinds of disabilities, it was what was the psyche of the people or the society towards them? Pity. That's the word if I use. So they will have sympathy with them. They will pity on them. Oh, such a person is suffering from this kind of disease or this kind of disability, etc. Over a period of time, and maybe those were the time they will be totally secluded. The person is not in a position to do anything because of, say, visual disability, or a person whose legs are amputated, etc. So, not in a position to do anything, is not a part of the society, and therefore we have to have pity on him, we will, or her, or we'll take care of them. From there, I think the next stage came, it became a health issue. Yes, we should provide them. They are the persons who are entitled to proper health services depending upon their disability, and we should ensure providing them their health. But ultimately, and that is what we see today, and which should have been, but yeah, it came also in other countries that for 40, 50 years ago, in our country maybe little over 30 years ago, firstly after the passing of the first Disability Act in 1996, that it has become a human rights issue. We have to see it from the angle of these persons, and we have to see, and I was really rather admiring this motto, the right to choose, the right to excel. This is the right which every individual in this country enjoys as a citizen of this country, and that is guaranteed in the Constitution of India. And therefore, the persons who are suffering from disabilities are not to be excluded. So therefore, it's a now a right to be included, inclusiveness, and it is based on, when I say right to choose and right to excel, is based on dignity. Here are two persons sitting with us on this dais only, Amar and Rahul. So they were given their right to choose. With proper education, they could, become good lawyers, and they have excelled as well. So therefore, this, the right-based approach, which Justice Manmohan also mentioned, is most important thing which has to be seen. And therefore, when the courts are passing the orders and different kinds of judgments are given, these are not, given out of any sympathy, if I may say, or out of any compassion towards this. But it is given because it is a right which is guaranteed under the Constitution. It is a right which is guaranteed under PWD Act, and therefore the courts are only doing their bit to ensure that the right which is guaranteed, it is implemented also in letter and spirit and in action as well. So in this context, when we see, and I come to your question now, is that how we do it? Justice Manmohan has answered in a different way when you asked him a different question about the monitoring, etc. But then, yes, as I have said earlier as well, and what he has also emphasized, sensitization. The judgments of the courts, if they are given, and even when these commissioners disability are passing orders, various kinds of orders, maybe in the executive capacity, as Mr. Avasti said, but then the implementation becomes very, very important. But judgment should not remain on papers. Then what's the use? That it's not that in a classroom in LLB or LLM we are teaching and this is but a beautiful judgment, exposition of human rights, etc. in respect of disabled persons. That is not the only way. That may be sensitization of the students, but then the implementation of the judgments, and it has to be ensured that the rights which are given when we are talking about accessibility, and which I started in Rajiv Rituri. I was lucky to have this immediately after the act, when this case came before me, and Justice Sunda Bhandare Foundation also was there, and then it is still monitored. And I'll come to monitoring, that is one aspect. But then more important thing is that the persons who are implementing, and even the every person in the society is sensitized, and it is not a matter of pity, it's a matter of their rights. And therefore we have to see all these individuals from this category also with dignity, and we have to ensure, and it should start from household itself, where the persons are the family members, that the persons who are in the family should ensure that they are given their proper, whether it comes to accessibility or proper education, and the state's role when it comes to employment, etc. And yes, I have said earlier also, for the sensitization as far as judges is concerned, now Mr. Avasti gave that example, when the case goes to a special judge, he doesn't even know that I am designated as judge, or he is not sensitized about this thing, that it has to be fast tracked and it has to be decided immediately. It is not like any other court. So therefore, first thing which is required at that stage, insofar as judges are concerned, proper sensitization and education of theirs, particularly at subordinate level in the judicial academies, which is very, very important. And as I've already otherwise indicated that as law students in the school, yes, there can be special programs about that. But I would say that even in the schools, I mean primary schools or middle level or high secondary schools, we used to have when I remember Justice Madan Lokar would remember, maybe Justice Manmohan also, the paper in civics, so civic sense, etc., all the civility which was taught, which is no more there. So it should be there. Another thing which Rahul also indicated, and I had, I think, discussed with him when he had come on one of the occasions earlier on CSR. Yeah, which is very, very important. Actually, now all the companies, public limited companies, they have their statutory obligation to spend, I think, 3% or some of their gross income towards corporate social responsibility. So it is spent on various other kinds of social activities, but why not for, and it can be, Rahul, I would say that yes, when it comes to giving the lawyers or the maybe your lawyers collect this initiative, this where they may have some reservation, but why not have some foundation where which is working for the cause, like Surinder Bhandare Foundation, and why not it should be given to them, and from there the funds can be utilized even for spending on the litigation as well. Then nobody would say about that. So that is, so sensitization is most important. And only one thing I would say here, to some extent differing with what Justice Manmohan has said about after the directions are given. Yes, he has said that it should be naturally there should be follow up on that by the courts. Courts should monitor. But he, where I differ is that when he said that look, courts have many other things, and therefore the executive or others who have to implement the judgment, they should be sensitized, which is important. But I think unless in this country the courts coax and the courts threaten the executives, and many times with the contempt also, things don't move. Let us be very frank about it. I remember one case, I was sitting in the High Court with Justice Sinha when he was Chief Justice in Delhi High Court, and under the old Act 1996, there was that the persons with disability get many benefits when depending upon the percentage of disability, etc. So that certificate is to be given, even the employment or education and many other things. So this PIL was filed saying that there are no designated hospitals, etc., which are not under that act. I remember the provision is that the government had to designate those who can issue such certificates. There are none. So how we get the certificates? So in that PIL, it was on the one hand Ministry of Social Welfare, on the other hand Ministry of Health, and both were parties, and the petitioner had made, and both were throwing burden on the other. Ministry of Health said that look, it is for the Social Welfare Department to do it. Social Welfare Department was saying it was, and it was going on for last I don't know how many months. So then what we decided, we said that within 1 week either issue it, or the secretaries of both the these ministries should be present in the court on the next date. And on 5th date, the this notification came. So this is many times you have to take these measures. And yes, courts are busy, courts are overburdened, no doubt about it. But then I think in our preamble, when we talk and we say that the preamble is the soul, first thing is justice. And when we talk of justice, I think, and the courts are given the primary responsibility to do this justice, and particularly social justice, we have to take time, even as judges, for these things. Yes, I mean, whether we sit beyond 4 o'clock and do this case for half an hour or 15 minutes, but we must do it. Thank you.
Thank you for that powerful thoughts, sir. I'll go back to Rahul with a question. Rahul, many times clients with disabilities have faced a problem in many courts that their cases are not heard for months or years, etc. And one measure that has seen significant improvement in is that is Delhi High Court has prioritized cases of persons with disabilities, in a sense that it is listed on top of the board when in the supplementary list, when fresh filed, and later on in the advanced list as the item number 1. Also, not just because it's a case of a person with disability, but also realizing the fact that some disabilities may need that kind of accommodation. So for example, people with invisible disabilities sometimes need access to dark rooms, access to silent places, and sometimes for them to continue to be in the courtroom and monitor the litigation, pace of litigation becomes difficult. So to accord greater opportunity of their cases being heard timely, this measure has been implemented. What could be some specific actionables that could be done across the courts to make sure that persons with disabilities have access to speedy justice?
Yes. See, this I think in my limited experience is the one key demand, that I see, or the one key request, I should say, that people with disabilities often voice in courts and tribunals across the country, which is, providing speedy justice and figuring out ways of ensuring that, their cases are promptly heard. Now, obviously, this is a demand that every litigant has, no doubt about it. And there can be two views on this, one view being that, look, everybody has to stand in the queue and, you will get your chance when you get it. The other being that, we need to take some special measures or affirmative action for this class of people to provide them access to justice, which also Section 12 of the RPWDA talks about. I think the measure which the Delhi High Court has taken has really been, a very positive step in terms of ensuring that these cases get the time and attention that they deserve. And I must share with you that there was actually a circular which was issued in 2016 on this to this effect in the Delhi High Court by the then Chief Justice. But when we became part of the accessibility committee, which Justice Shakdar was chairing at the time, we realized that that circular was not getting implemented at that point in time. So then a framework was evolved to have this be a separate category and put it on a priority basis in the cause list. So that kind of affirmative and targeted action can really go a long way in providing speedy justice, whether it be in the Supreme Court or any other courts or tribunals. There are not going to be too many cases of these people. It's not like the regular work of the court will get significantly stalled, in my limited assessment, because this is not one of the areas where like unlike bail matters where you will see a large volume of cases, but it is extremely significant. So I think that is very, very crucial. As an institutional reform, I would suggest that. In the meantime, I think it is for the lawyers concerned to really, until that happens, to impress upon the concerned judge that, look, this admission deadline is about to pass. This is the case of a person with a disability. Please take it up on a priority basis so that the purpose and object doesn't stand frustrated. And that then depends upon the workload of that judge and, what their perspective is on the issue. So these are only the only two things that I can think of on this, really.
Thank you, Rahul. Coming back to Praveen, sir.
One point, if I may
Yes,
just add, I'm so
please.
sorry. One aspect which I think which is also important here is the disability commissions also, I think, have a very important role to play, because we are the need to go to a court of law like the High Court, Supreme Court, CAT, etc. for persons with disabilities arises if the issue is not satisfactorily resolved at the level of the Disability Commission. Now we are, in an age where we are having specialized forums for everything, from National Green Tribunal to Competition Commission of India, and the Disability Commission are also a step in that direction. I personally think there is a grave need to strengthen the powers of the disability commissioners. And here I would disagree with Praveen sir respectfully. I think as of now, the statute only gives them the power to make recommendations, and obstructionist and recalcitrant institutions, of course, some will comply and it's good if they are, but we can't just be dependent on their goodwill. So there are obstructionist and recalcitrant institutions that choose not to comply. And for that, we need to vest the commissions with the powers of contempt with the powers of imposing penalties. Of course, with that, you may need to have requirement that the persons manning them may be judicial officers with so and so much experience. Those institutional changes would need to be made. But thinking of the disability commissions as an arm of the judiciary and not a part of the executive is, I think, also an important step on this in this regard. Thank you.
Thank you, Rahul, for that. Praveen sir, coming to you, and the office of CCPD has really played pivotal role because many times complainants come to you without having adequate knowledge of law. Sometimes complainants are anxious, they need psychological support, they need counseling. Sometimes people fear actions. If they take any, if they institute the complaint, there may be some retaliatory measure taken being against them by the institution concerned. What in your opinion, other than the having the legal forum like office of CCPD, etc., could be some of those measures which could improve clients with disabilities perspective and mindset, and provide them a supportive environment to bring disability rights issues to the relevant forum? What could some of those measures be?
Thank you, Amarji. Your question seemed very, very simple until you used the word client with disabilities, because then again we are going back to the judiciary maybe. But yeah, and first of all, can I answer Rahul?
Sure, sir.
Yeah, what I meant to say is that in the current context, with the current mandate that we have, that is what we can do. But yes, of course, CAT is also a purely executive body, of course, with judicial member, with the admin member. But
That is wrong impression of yours. That is not an executive body.
sir, it is formed by the executive, sir, paid by the executive.
No, that's a
And
different thing.
yeah,
That's
yeah.
administration.
Yeah, but
It's a quasi-judicial body.
sir, that's
It's a tribunal,
yeah,
judicial tribunal.
yeah, sir, that's what, because it is paid by the voted expenditure,
That's the
not by charge
that-
expenditures. So what I'm just trying to bring out the similarities, sir. Similarities. It is also created by executive for the executive. Of course, the judiciary employees from judiciary.
Stated by executive, it is stated by constitution.
That's so.
By amendment in the constitution.
Yes, sir. That's what I was coming to.
Statute passed.
I was coming to, because it is a constitutional body with the powers of review and contempt. It has got more efficacy. Something of that sort can be thought about for CCPD. That's what I was trying to say, to bring them at par with CAT. The constitution actually doesn't speak about disability at all. So unfortunately, but about the CCPD interventions, I would say to within the given mandate, how we can use the efficacies. One is, as I said, almost 60% of the cases are from service matters, and in the Act itself, Section 23 provides for a grievance redressal officer, and that has not been implemented much in the government departments. So that is also what we are trying to monitor. In every notice on service matter, we are making mention of Section 21, Equal Opportunity Policy, and Section 23, the grievance redressal officer, and we are trying to get the view of the GRO. So at least in that process, the GRO will be appointed in the organization, where right now there is no GRO. Once the GRO has applied its mind and disposed the matter as per the Act, they have got 14 days time. Then thereafter the matter can come to the CCPD office. So that is one way of strengthening the departments itself for the benefit of persons with disability. Similarly, same kind of thing can still happen with judiciary and legislature, even without any proper provision in the Act. So therefore, matters, of course, on accessibility, judiciary, almost 11 or 12 high courts have accessibility committees. But other than accessibility issues, if somebody wants to come without having to go to the formal judicial courts, then that opportunity can also be thought about. That will also give some impetus in the disability right movement. And
Would you want to touch upon, sir?
Training, yeah, I think only the UP Academy has got RPWD in the syllabus. So, sir, Justice Sikri was talking about sensitization. Training will be required for not only for judicial officers, everywhere. Right now, we are having a suo motu matter against 27 training establishments, including from Labasna to all the major Group A and Group B training establishment where we are asking, number one is having an accessible campus, number two, accessible study materials, number three, their website should be accessible. And in the last hearing on 11th of July, the CCPD also started a new process of having a kind of a purple training programs where every training establishment within this year 2025 will have 1 week of training program on disability matters. So we are already collaborating on that. So these things will definitely help us going further. Thank you very much.
Thank you, sir. I'll come back to Justice Manmohan. So, with your closing remarks, I'd like to hear from you. When any matter of disability rights come to courts, and especially at the Supreme Court level, what becomes more important? Is it really the process setting or is it really the precedent setting?
See, it's like asking a fan of cricket or a cricket lover, would you like to play a T20 or a 5-day match? See, both are crucial. And in fact, if you ask me, at times when a person approaches you, he's in dire straits. He requires immediate relief. It may be that he's been denied access. It may be that he's being discriminated against, which is real and substantial. It requires a quick redressal. So the issue is that would you concentrate on the interim aspect of the matter, or would you like to lay down jurisprudentially a correct law? According to me, it is not just confined to the interim order. Because if you're approaching the matter only from the perspective of dealing with the immediate problem on hand, and that is granting interim relief to the person, then it is indulging in a sort of ad hoc, in a very ad hoc way, and you will not be laying the true foundation for that relief. It must be the relief must be grounded on good, sound legal reasoning, and that you will find only when there is a detailed jurisprudential judgment on that aspect. And only when you have good jurisprudential concept laid down in a judgment would it be followed as a precedent, and would it be applied uniformly, rather than just giving relief to one person by way of an interim order. So I would think that one will have to grant interim relief, but found it on good legal principles so that it becomes a legal precedent, and it becomes a precedent which can be followed by everyone. It must be rooted in law so that everyone knows that no one is giving charity. It is based on a right. It is based on the interpretation of the act, which is giving reasonable accommodation. In a nutshell, I would say it has to be, the judgment of the court has to be based both in empathy as well as vision. If you don't have both, it will be lacking. And you must grant interim relief because that's the need of the hour, but it must have a sound rationale to support it. Otherwise, it'll just be a one-off remark giving relief to one person rather than the entire community.
Absolutely.
And God forbid, if the court goes down the wrong line, it can happen. It'll get corrected because you have given some rationale behind it. That rationale, if it is not appealing to the public or to the legislature, they'll correct it. They'll pass an amendment.
Right.
So it's very important to lay down the law properly. When Justice Sikri said that, I was saying that it should not be continuously implemented. I was only saying that let's be realistic about the situation.
Right.
If you think the court is going to monitor a matter on a daily basis, it may be raising the hopes too high, which will not be implemented. Because see, to expect that a judgment would be implemented on a daily basis is very difficult.
Right.
And we have to be realistic, and we have to ensure that all organs of the state work towards it. Today, everything can't be left at the judiciary's doorstep. If you think that only judiciary is going to resolve the problems of this country, you're sadly mistaken.
Right.
We may just compound it at the end of the day. See, unless until all organs, including the society, works for it, we'll have a tremendous issue at hand. And let me just give you a simple instance in Delhi High Court, what we did on the administrative side. It is not just on the judicial side where the courts can work, just look at the administrative side. We have just opened a small cafeteria which is run by the mentally challenged children. It's a absolute homegrown initiative of the Delhi High Court, run by Shaurya Foundation, of which its convener is one of our senior lawyers, Ravi Gupta. His child also suffers from that disability. And we have opened, just given them a small area to run a cafeteria. The children are running it primarily. They have tied up with Sagar restaurant. Look at the number of people, the lawyers who go there. Look at the people, look at the way the people are sensitized about that issue. When you go to that cafeteria and then you come back to court and you understand when a rights issue is being argued over there, your whole approach will change.
Right.
When the judges go to that cafeteria or they call for something from that cafeteria, they understand who's running that place. Just see, you need empathy in the society, which is lacking. We have complete lack of understanding of the issue that we are dealing with. That is persons with disability. Unless until you have an understanding, you will not be able to approach the issue. And that, I think, is very, very crucial, rather than just laying some abstract principle of law, you know, just for consumption in the newspapers or in the textbooks. So the real issue is to sensitize the society, to ensure all organs of the society work together, and one should not expect that it will be solved only by the judiciary. If you think it will be solved only by the judiciary, I don't think that's very accurate. We may take the lead in the matter because we are people who have gone through a legal training, who are educated, who understand the rights of the persons suffering from disability. We can surely take the lead, but it will only get implemented at the ground level when you and I work together. And that, I think, is the core issue. These sort of seminars serve a huge purpose when they are sensitizing each one of us in this room of what is the issue that we are grappling with, what is the dimension of this problem. See, the whole approach needs to be changed. See, we cannot approach it from a feudal mindset that today I have the power, I will do something for you. It's not that. We are not doing any charity. I am repeatedly saying we are dealing with person who has a right in law. That right needs to be given to him. He must be aware of his right. He must come in case there is a grievance. He must be able to raise it with the executive, with his member of parliament, with his MLA. They must be able to deal with it on a timely basis. The person to whom he goes and raises his complaint must be aware of his duty, must be aware of the disabled person's rights. And I think that is very important. Therefore, I think what needs to be done is that we need good legal foundation, which should be done by way of judgments, but people need to be sensitized and it needs to be implemented at the ground level.
With that very strong foundation, and before I go to Justice Sikri for his conclusive remarks, what we have really uncovered today is the need for bringing legal reforms, need for bringing sensitization, need for executive, judiciary and legislature to work in tandem to make sure that the historic judgments that are laid down by the courts are realized in its true potential for the society at large. And I now come to Justice Sikri. Sir, you have laid down futuristic vision always in your judgments, be it Jija Ghosh, be it Rajiv Raturi, and many more. In your opinion, what is the future of disability rights? In my humble opinion, now the time has come where we should move from rights approach to value-based approach, where person with disabilities value is realized in the society as contributor to the economy, as contributor to the society, and as a citizen. What in your opinion could be the future of disability rights, and how people with disabilities should be viewed in near future to come?
I think you have hit the nail. That is what I wanted to say at the end when I said that how we have progressed and we are at right base from pity to health issue to this and now value based. And again, I go to this motto of Sunanda Bandare Foundation because ultimately it is whatever are the potentials of a person, whatever is the worth of a person. And I say that when we talk of inclusivity also in the society, that means each and every person, irrespective of their disabilities or I would say abilities, etc., they are important part of the society, and everybody has right to contribute towards the progress of the nation. And it would be a misgiving and a very shallow thinking or narrow thinking to say that only the persons who are so-called able, if I'll use that expression, only they can do this work and not the other persons. So that is a very myopic view of what the other persons can achieve. We know now that how in Paralympics our people have done wonderful, in the last Olympics, how many prizes they have won. In various other fields, it's not time to recount all that, how they are doing. So therefore, it is, we have to now recognize the value and value based, and that approach, I think now, yes, Justice Manmohan is there. He's still a sitting judge. Whenever he gets a chance, now we have laid down the foundation of rights based. So let it now come to value based also, the next step, which would be very, very important for inclusivity and for recognition of, or giving due recognition to the persons with disability. I think that's the next step, and I won't here include only the persons with disability, but the last session also, which is coming there, the value based there as well. Thank you very much.
Thank you so much. I think, honestly speaking, if you want to read about Rights of Persons with Disabilities Act, the couple of concepts before I open up for questions and answers, you'll read up on non-discrimination, that no person with disability should be discriminated solely on the ground of disability. The concept of accessibility, which is to ensure that every person with any ability is able to access products, services, and environment. The concept of reasonable accommodation, which is basically a specific individualized measure that is taken when accessibility fails to accommodate their needs. All of these concepts are actually, if you see, have been put into the act because ultimately the idea is that a person with disability should be able to realize their full potential, not because it's a right for them, not because it's an obligation, but because it is a means to make sure their value is realized in the society as a contributor. With that, I open the floor for any questions and answer.
I think because that's what I was telling him. Next section.
So can we do one thing? We can do the question. If anyone has anything specific, we can ask when we have our tea.
Sure. So, apologies for not being able to timely finish the sessions. Questions were important and opinions were important, but look forward to see you on the break with any questions that you may have. Thank you.
I just very quickly, I want to just thank. I had a lot written here, but since we are running out of time, I want to thank Justice Manmohan, Justice Sikri, Mr. Ambasta, Rahul and Amar, of course, and Archer from QAble for coming here today and so passionately discussing and talking about these issues. We really hope that in some small way today's conference will make a difference. I want to just tell you, when we were talking about how sometimes the executive and all does not, and I can tell you in our own litigation, the Justice Sunanda Bhandare Foundation PIL, it was filed in 1998 when the old act was there. Till 90, even then, even though we had a judgment which said all states would comply with the old act, none of them were compliant. Then in 2016, a better new act came. 2017, we got a judgment saying that now you will all comply with the 2017 act. And till date, the Supreme Court has been monitoring it. Despite the fact, I mean, by now, but can you imagine? I think the last hearing was about 4-5 months ago. Still, some of the states and union territories were not compliant fully. That is the state of affairs, sadly, in our country. I do hope that, discussions like this will make people and the society at large and the executive and judiciary more sensitive to these issues. And I also, one of the most important, I think, things which have come out in today's conference is bringing relief in court, not from pity to dignity, but. And that is the need of the hour. With this, I thank all our panelists and all of you for coming here today. And of course, all of you will continue to be with us, but I'll request you all to please join us for a cup of tea and coffee. Thank you.
Thank you so much for having us here. Thank you.
Yes. Okay, so taking the conversation forward, our next panel is about lawyering with women with disability. We are being moderated by Miss Namita Bhandare, who is a senior journalist and has been working with the Hindustan Times. When gender comes in conflict with disability, it not only becomes difficult to navigate, but it is not only difficult, but it also becomes almost impossible to navigate. And taking this conversation forward, I hand it over to you, ma'am. Thank you.
Just one correction, I'm actually a freelancer. But I write regularly, or write for Hindustan Times and on gender. That is my my obsession. So as journalists, we have a bit of a reputation for being hard to please. But when I look at some of the landmark judgments in the past decade and a half, that I've been covering gender issues, there is so much to be proud of. We have made undeniable progress plugging some gaps to ensure constitutional guarantees of equality to women. These include from Sabrimala, Shaira Banu, same-sex relations have finally been decriminalized, and transgender people now have the right to self-identify. To be sure, there are many mountains left to conquer. I think marital rape is one. We must address it in a country where 1 in 3 women is subjected to domestic violence. It's a shameful statistic. Marriage equality is the other one, and it will give truer equality and inclusion to LGBTQ couples. It's an idea long overdue. Where the rights of people with disability go, here too there has been some progress, and as the first session elaborated in great detail, the Rights of People with Disabilities Act. Also landmark cases, Suchita Srivastav, Patan Jamal Wali, and so on. Globally, 1 billion people live with disabilities. And historically, disability has been framed as a weakness, a lack. Something is lacking. The word, the root of that word, it's something, there's ability and there is disability. Laws have traditionally been framed as Justice Manmohan very correctly pointed out in terms of charity, pity, or protection, much more than rights. I'm sorry, as a journalist, I need the written word, otherwise my brain doesn't work. I think the questions before us now is how do we create a civil landscape that is inclusive? If you look at the civil landscape, it is designed by and for able-bodied upper caste men. How do we create a landscape, not just legal, just a social landscape that is inclusive of women, of children, of LGBTQ, and also of those who live with disability, who are erased from public life and hidden from public view? So to discuss this layered but urgent issue, I am excited to present my very distinguished panel. Right by my side, you all know Justice Neena Bansal of the Delhi High Court. With her wealth of experience in civil and criminal courts, from matrimonial disputes to motor accident claims, and from POCSO to the Prevention of Terrorism Act. She was the presenting officer in the National Human Rights Commission and the first ever director in the Department of Law and Justice, Delhi, for setting up the Delhi Dispute Resolution Society. Next to her, we have senior advocate Jaina Kothari, who of course I've known only by reputation. I think we're meeting for the first time, but oh dear, wow. She is, can you hear? Can you hear? Shreya's gone to show some muscle. So, Jaina is, can you hear? Should I wait? Okay. She is the executive director and co-founder of Center for Law and Policy Research. Her practice in the Supreme Court touches on matters of constitutional law, gender and sexuality, disability rights and discrimination. Her arguments were heard in the apex court in such landmark cases as the decriminalization of 377 and also of adultery. Her advocacy in independent thought led to the Supreme Court recognizing child marital rape as a criminal offense. Here we have Sanchita N at the extreme end over here, who is an advocate on record in the Supreme Court. She has an LLM in international human rights law from the University of Essex. As a woman who lives with disability, she brings a unique and intimate perspective on navigating the law as a woman lawyer. Sanchita has argued landmark constitutional cases including triple talaq, affirmative action, rights of minority institutions and other civil, corporate and family law matters. She is also a fellow of I Can Lead, which is India's first national leadership program for women who live with disability. And then right near me, next to me is Shampa Sengupta, a Kolkata-based activist working on gender and disability issues. I've got quarter of a century, but she just corrected me and said for 40 years. So we are contemporaries. She is the founder of an advocacy group called Shruti Disability Rights Center and is the joint secretary of the National Platform for Rights of the Disabled. As someone who works so closely on the ground, she brings in a unique and personal perspective. So without further ado, now that Shreya has silenced all the noisemakers, I'm going to get started with Justice Bansal, with you. You know, the Rights of Persons with Disability Act, when it was passed in 2016, was seen as a transformative shift from the earlier law. I was wondering if you could explain on how it broke. What were the important ways in which it broke from the past? And in its practice and implementation in the courts over the past 9 years, where do you see it falling short?
Good afternoon. Uh, I think the question is oxymoronic, because though we have said we have left the a charity attitude to a rights-based law, but I think practically we all have the same mindset. No matter how much we are trying to say it's an entitlement, but what we need more than law is also a different way of looking at things. The first starting point with this new statute was that at least there is a legal framework, a base where you can, or all of us have started looking at things a little differently. Earlier, and it's a fact that the minute you see somebody with some limitation, a thought does come into our mind whether they would be able to. The first thought is of pity. And that is where the shift has come in with the act, that we have started recognizing is as not a person who's become less, but a person who has worked a little more, has become acquired more accomplishment maybe than what a normal person would do. Any time we are faced with a challenge, we need to work a little more. So what we need to appreciate, admire, is the courage and the hard work that has been done to meet that shortcoming and to be on a level play field. So where law has helped us is the framework. They have given you where you can assert your right, and this has also helped us by way of awareness. And what has got implemented time and again, I think Supreme Court has been intervening to ensure that every workplace becomes friendly. Now everywhere we have those raised tiles to indicate. I remember in the conferences we never had these, the ramps, and it was quite a difficult situation. We were in NHRC, which is actually working a lot, and there was this conference, a similar one, and some participants and the speakers were unable to come only because there was no facilitative lamp for them to come up. Of course, we struggled, we managed, but it's something which is missing. It is something which is because we are not conscious and aware, and that is where the law has come in, where it has become mandatory in academy. I would like to, share how ignorant we are. We have a regular toilet, and this person, and the doors are always small. The wheelchair would not go in. And what difficulty that person had, we all struggled, tried to find some alternate way. That is where the dignity gets compromised. It's a time, there is a definite shift, but a little more where we are conscious that what we were talking in NHRC is not they are disabled, but they are differently able. So a little different approach and comfort is required to be provided, and they are as normal as anyone is.
Sure.
I mean, this is
Yeah,
a
thank
small
you.
comment.
Thank you so much. Jenna, I want to come to you next. I very briefly mentioned in my introduction about a slew of judgments where you suddenly have, these gaps, long years of gaps being plugged. Even in 377, it just went through this roller coaster, up, down, but finally decriminalized, where gender you have. Has disability law kept up? Has disability rights kept up, or rights for people who live with disabilities, with the other kind of, guaranteeing of constitutional equality?
Yeah. Thank you for that. And first of all, thank you to the Sunanda Bhandari Foundation for also inviting me, and so that I can be part of this wonderful panel. I think it's a really pertinent question, And yes, I think in the last few years, especially last 3-4 years, we can say that the movement that was there in on gender identity, sexual orientation. We had the Nalsa judgment, we had the 377 judgment, and all of those judgments which changed the landscape on gender identity, and sexual orientation. We have that happening in disability rights. We've had a slew of Supreme Court decisions in the last few years, whether it is the Jija Ghosh judgment, whether it is the Vikash Kumar judgment, the Rajiv Raturi judgment, and recently a couple of more Supreme Court decisions which have just come out in 24-25, which range from which lay down the law in a very elaborate way. They look at equality and non-discrimination. They look at the non-provision of reasonable accommodation as being a violation of equality for persons with disabilities. There are a range of judgments on accessibility. The Jija Ghosh judgment talks about, applicability to private actors. Vikash Kumar laid down the framework for equality. So, we have all these really brilliant judgments. We had actually a judgment of the Madras High Court a few years ago by Justice Mahadevan, who's now in the Supreme Court, on intersectionality, where a woman with disability who was an athlete, who was a female athlete, but was not allowed to participate in an international sports meet only because the organization said that how can she go alone as a woman with disability? And for that reason, despite being the topper in her event, she was unable to go. And then the court directed that she should be sent, and that this amounted to intersectional discrimination, both on account of her gender and disability. So we have a range of some very, very important judgments. The question really is that who's reading these judgments? Is it just people from the disability rights movement, disability rights lawyers, and people perhaps who are interested in a rights-based, study or work? But if other lawyers and other judges and other people, whether it's from the government or other stakeholders, are not reading these judgments, then these judgments just become, as said in the previous session, they become wonderful judgments for study, but not really for implementation. So really, how do we make these judgments stand out as judgments which expound equality generally? Of course for disability, but equality generally.
We'll have a Q&A for the audience later, because we can't keep having it in the middle. Shampa, I want to talk to you, and I want to pick up from what Jaina said, and I want to pick up some ideas about what was said in the first session. Two things, one is, could you expand on the idea of intersectionality, to a lay audience? It's a two-part question. And the second is, I want you to again pick up, as an activist on the ground, what are the gaps between what is promised on paper and what actually happens on the ground? It's a very broad question. I'm sorry.
Thank you, and thank you the organizers for inviting me to take part in this dialogue. And I'm probably the only one who's not a lawyer. So, but when you work for so long, like when I first started working, even the 1995 Act was not there. So I keep on saying I'm older than the disability movement in some cases. So I think the major problem of our sector is lack of information. We need to understand that. As in the first session, it was being said that the CCPD's office is getting more cases from regarding transfer issues, regarding service related issues. But if you think of the RPD Act, there's a vast range of rights which are given to us. And I personally, I have two different kinds of disabilities. So I have dyscalculia, and I also have psychosocial disabilities. So I will fall under Mental Health Care Act, I'll fall under RPD Act, and of course all the women related acts are applicable to me? If we think of that way, and even being so much privileged, do I even know like where to go, where to actually lodge a complaint if a violence happens to me? Because there are so many times, because my focus of work is of course on sexual violence on women, and I have women with disabilities, and I have seen that when you talk about intersectionality, like people don't know. The police officers will say, but this is not a, like if you go for with to lodge a complaint, they will say this is a rape case, this is not a disability case. So the of course in Bengal we do not have a state commissioner for last 4 years, so we have like a part-time person, but the commissioner's office will say this is not our case. Sexual violence is something we'll not look upon. Even though RPD talks about women with disabilities, it's also very important to understand that, and I'm particularly, because there is a separate session in the next session, I'm now focusing on cis women in this session. And if you think of the RPD Act, there are so many clauses on women with disabilities, but tell me in which, because again disability is a state issue, so which state, also at national level, we do not have the rules. If you look at the RPD rules, the RPD rules does not include those gender related issues. So it's something, I mean, there is a big gap from the beginning to towards the end. And if you think of going to the classroom, the knowledge is not there. How can a woman from a rural Bengal, because I come from Bengal, I'm giving that example, how will she know that where to lodge a complaint, how to lodge a complaint with CCPD if any kind of violation happens to her? And this whole process of online complaint is also a big challenge, and we need to understand that. Of course, we are here in a in Delhi capital, this AC room, but this is not what disability, people with disability comprise of. The population is something totally different if you go to the ground level.
Correct. Thank you. That's quite heartbreaking too. I mean, Sanchita, I want to come to you and ask you, if you don't mind sharing with our audience, what is it like to navigate the justice system as a person who lives with disability?
I think I would like to begin with a story. I have quite a few stories, but I would like to begin with one. When I was in class 12th, I dropped a year because I wasn't sure if I can write an exam. This is pre-2016, when my disability was not even recognized as a disability. So I could not ask for a scribe. So I dropped 1 year. And still I wasn't sure, but this time I had to write it. This was West Bengal board, where we used to have 2 papers in one day, 3 hours, 1 hour break, and 10 to 1, and then 2 to 5. Last paper, political science, I really thought I can't make it. And the kind of excruciating pain I can't explain. And I just said, I wanted to escape. I didn't know how to escape from that situation. And I said, God, can you just fast forward this time and bring a time when this is not happening? And then I added to it, not happening just to me, but to anyone else. And then years later, during COVID, during a virtual hearing, I was appearing before Justice Chandrachud, as he then was, in a Disability Rights Matter, which came from Tamil Nadu. And he was hearing a case of a doctor who wanted to write UPSC exam, who had the same disability and wanted a scribe. Now, when the act had come, I was very happy. Now it's resolved. I was waiting for the act to come. And then when I heard in courtroom, and it was the first time I actually heard that the guidelines said that only persons with benchmark disabilities can ask for a scribe. I was like, what the hell did that come from, right? And it was actually being argued, which didn't make sense to me. Why is it even being argued? It's commonsensical for me. And then when my matter was called out, this was pushed for end of the board, and when my matter was called out, after arguing my matter, I volunteered and I said that I may have some input, so if I may be allowed to argue it. So, coming back to what Justice Manmohan was saying this morning, where interim order, how essential interim order is, but it's also essential to lay down the general law, that got tested in that hearing because the judge was inclined to only give the doctor relief because it was too much to go into in a way, right? So they were not sure if they can really lay down guidelines because everyone will then come and ask for a scribe. Now, this was the view of the court at that time. I was like, I just need half an hour. And I was so convinced that in half an hour, I would be able to show them a different view. And I would be able to show that how ableist it was to think of how it can be abused and therefore deny someone who deserves it, who needs it. And to show them that without it, the person's very basic for that person's existence to have it. And that cannot be compromised. And that's what led to Vikash Kumar's judgment, which is now being cited and people are claiming the relief that they're getting. So when we argue such cases, when we understand the kind of impact it's going to have on not just that litigant's life, but the public at large, and to have that vision as to what you want that judgment to say. The reason why I chose to be on this side to litigate was exactly because I thought that it's possible to kind of steer through and guide the judgment in the direction I want. The second aspect that you were asking me about how it is for a lawyer, woman lawyer with disability, for again to be visible, even for a lawyer with disability to be visible. I mean, people, before I had organized a coffee chat in Delhi High Court, people had people didn't know that there were lawyers with disabilities in the High Court. Okay. And then things shifted. People suddenly spoke. Someone said that they spoke to Arvind, and for the first time they spoke to him as a colleague and not someone who as just a person with a disability, right? He got, and this kind of event, that's why helps. It helps to talk about real issues in these kind of events. He got to do something that he really enjoys doing after that coffee chat. The Delhi High Court Legal Service Committee created a panel. All of this happened out of it. So let's also look at something concrete out of this and see how can we make easy for women with disabilities and persons with disabilities and lawyers with disabilities. Because it's very crucial that we understand the impact it is having on people, right?
Thank you. Justice Bansal, I will come to you with the questions, but not in the middle of the discussion, please. Justice Bansal, I wonder if you would like to respond to Sanchita. And, because one theme that is emerging from the morning's discussion and continuing through this one is, empathy. The role of empathy, whether it is in the executive, whether it is in the judiciary, and of course also the lack of awareness and training amongst the magistrates. So a woman with disability has a complaint of rape, she's just bounced off from one department. But I think the root problem here is a lack of empathy.
Yeah, I think I agree 100% with what you are saying, because what has been said here is that to say and to do are two very, very different things, and there's a huge gap between the two. Awareness definitely has come in. There is a shift, and I think a lot can be said to the judgments which are being given. Even if it makes a headline, there is a lot of awareness which goes, and it is only with awareness that we would be able to bring in a change in perception and also bring in a change Having said that, I think the courts per se, be it district courts, be it high court, be it Supreme Court, wherever we are getting an opportunity, I think nobody is missing it. What has been said is very important, that many a times we are not even aware and conscious. If I'm looking at somebody, I may not even be aware what the point you were making, that unless we are aware, we cannot address. And that is where very important aspect is coming in. Disability has become a regular discourse. Even in the academies, there is a topic which has become a routine discussion. So it's no longer a taboo thing, no longer a pity thing, it's a matter of right. As what in law and what as a person who has a little privilege to bring in change can do. And there, I think there is this difference in how we are interacting, dealing. A person maybe, having a vision disability, hearing disability, is not being shut out. I think we are all extremely open, and wherever there has been a gap which has been felt in communication or any kind of additional equipment that is required, all of us are, working for it, and we ensure that nobody gets left out so far as our legal framework.
Yes, thank you. Jenna, I'm going to come to you in a minute, but I just want to bring Shampa in for a second, because something, which just occurred to me, social change. You bring about, so, after the December 2012 gang rape in the bus, there was so much public anger, and you have the Criminal Amendment Act. But you did not have the corresponding social change. Nobody wants to do that hard work. You will sit. So in Calcutta, also West Bengal, they brought in the Aparajita Act, which is of course now awaiting the governor's assent. But the corresponding social change is not happening. So where do we stand with disability? How do we bring this conversation? How do we outrage people in a sense and make them aware?
Thanks for bringing that in, because I think after 2012 Delhi gang rape case, because my work on particularly on the intersection of women with disabilities started with a gang rape back in Kolkata in the year 2000. So I thought when the Justice Verma committee was formed, and I thought that this is a really, really good opportunity to talk about women with disabilities, and I'm bringing changes in the criminal law, and it was a very interesting journey. I'm saying this because I think it's very important to understand also. When we came to Delhi to meet Justice Verma committee, the members, the committee members actually told us that there are like thousands and thousands of recommendations came in. Only 7 groups wrote about women with disabilities, and yours is the only group that which gave us concrete cases of like where discrimination is happening. So starting from the police station FIR to, because you have to work from the beginning. Court to baad mein jate hain, like you have to start from FIR and the whole process. And we sat together and drafted and I saw the criminal law changed. The amendment happened in 2013, and there were I think I was very ambitious. I thought we have done a lot of work and very good things will happen, because we have got a lot of good clauses now with so many good practices now coming. But where is the implementation level, and why the implementation is not happening is because changes didn't happen in the field level. So we said that this woman will need support services when going from the beginning, from the court to the whole legal process. Unfortunately, we don't have enough support persons, and we need to understand that we don't have enough sign language interpreters in the country. We don't have enough special educators in the country. We don't have that kind of infrastructure in a country where we told that the when all the interrogation will be like video recording will be done. But just imagine when we went to the rural areas and so in fact in one of the case I was following, the police officer was very nervous when I said that video recording is important, this is a law, and he tells me, so should I like record with my phone because I don't have we don't have that kind of infrastructure in the Thana level. And that is a reality, I think, all over India. It's not only West Bengal level, like everywhere this is a scenario. So if you don't change the infrastructure, I think in the morning also this discussion happened that change have to come both ways. It cannot be like up-down approach. So a law changes, but the ecosystem doesn't change. So it doesn't really help the survivor of violence.
Correct. Jenna, I really, as someone who's worked so closely with disability and gender, I really want you to weigh in over here. The gaps in infrastructure, the many gaps that we're talking about.
Yeah. So one, of course, is the gaps in the infrastructure. You have the legislation, you have law reform, but then do you have the rules and the infrastructure to back it up? Social change may still take time. But are we able to even implement the law with the infrastructural requirements, whether it is by the support persons, video cameras, and all the other measures required? And so on one hand is that, but I think for there are for women with disabilities. If you talk about implementation of the law, the challenge is far more than just implementation at the government level. You talked about rape and sexual assault cases and the lack of infrastructure at the police stations or in the courts. We are facing, even understanding the law, filing complaints, and challenges in the private sector. On one hand, you may say the private sector may not have the resource problem, right? Many private sector entities have the resources, so they can provide. But we see that there are severe challenges there. So, for example, there was one case in which judgment is reserved, but one case in the Karnataka High Court where there was a teacher in a private school, a very well-resourced private school. The reason I'm talking about resources because there should not be any resource crunch. In a very good private school, she acquired a disability. She was a teacher studying there, teaching there for many years. She went to save a child who jumped off. Tried to commit suicide in the school. The teacher didn't think about herself and jumped off trying to save the child and has become completely permanently disabled. What is the response? The school terminates her appointment, pays for some medical care, some initial medical care, and then terminates her appointment saying that she is not fit to teach. She goes to the Commissioner for Disabilities. The Commissioner passes an order that she has to be reinstated with full back wages and at the same post. They don't comply and they go challenge it in the High Court. And then as a charitable measure, they say, well, she's not in a position to teach because she's permanently on a wheelchair and therefore she can just be an administrative assistant for 15,000 rupees a month. And then in the case, when we argued and the court said, well, I said, she can easily teach. She can resume her position as a teacher. She needs reasonable accommodations. And so the court said, well, what are the reasonable accommodations that she wants? Why don't you make a list and give it on affidavit? And the reasonable accommodation that she asked for were so minimal in terms of resources. She said, I want classrooms that are on the ground floor. I want a 15 or 20-minute break in between, every 2 hours. So that I get some rest. I want the flexibility that on some days, if I'm unable to make it to class, I should have the option to do online teaching, and the curriculum should suit my timings. That's all. And she said, I want a transport allowance because my wheelchair doesn't fit into the school bus. because they didn't have low floor buses. So she said, if you don't have low floor buses, at least give me a transport allowance so that I can have a car or a taxi. And the school said, we don't have the resources. So then what are we talking about? So on one hand, yes, it is about resources and infrastructure, but on the other hand, it's also an attitudinal barrier, that are institutions, whether private or public, willing to take those measures that are required, that the law requires. So it's really an attitudinal barrier. And again, I would concur with Justice Bansal that it is the mindset still hasn't changed. You're saying that I'm giving you this, you should be grateful that I'm giving you an administrative position.
And of course, a lot of the problems coming from the families as well, the prejudice, the discrimination, girls with intellectual disability being forced to undergo hysterectomies in the name of protecting them. Apparently this is reportedly, I'm talking about news reports, this is quite common. Did you want to add something, Shampa? Because I'm going to open it. How much time do we have? Yeah. Okay, yeah, I want to keep 10 minutes for audience.
I just wanted to share some experiences of representing women with disabilities. The issues are quite many. Most of them stem from the sense of the vulnerable position they are in their families, in their workplaces. Most of them are not getting reported. The number of cases that come from women with disabilities is far less than what it actually is. Whether it be domestic violence cases, and mostly they are not even in a state to go out of the house. They are dependent on a caregiver who themselves are the abusers. Even in cases like during COVID, we managed to save a woman from a flat, and those flats are worth crores. And we sent her to a home with the help of the police. Later on, I got to know the husband had come and taken her away. So this is a situation where the society is still dealing with the gender issues as if the husband had a right, and particularly when she's disabled, maybe he had a greater right on her. Same thing happens with women children. Their ability to decide is highly compromised more than male child with a disability. When they go to a doctor, even those kind of, they say, oh, you are overreacting, right? These kind of issues which are not even identified as issues, which are yet to be seen as discrimination. We are not even talking about fathers committing violence. We have not even reached there. I had a case where, and I also really like the motto, by the way, freedom to choose, because that's what is missing the most when it comes to women with disabilities. There was this case where the father calls me and he says it was a case of divorce, and he says that you just ask her to settle. So I thought maybe he doesn't trust me. He has trust issues with lawyers. He may be thinking that I want to make money out of the case. So I said, look, I won't charge you a penny, but let me first speak to her and understand what she wants. So he didn't let me meet her at all. So these are the kind of situations that women with disabilities are more likely to face. And in workplaces, again, the sexual harassment, the reporting is far less, because they find themselves to be in an extremely vulnerable place. The ableism is so strong in the society that they are also a part of the same society. They also carry the same conditioning, something that we really need to address. And as lawyers, being a lawyer, the changes that we really need is that if we can, educate and sensitize the lawyers, judges, even counsel standing on the other side. I have never heard, these days you don't hear sexist remarks being made openly in Supreme Court by a lawyer on the other side, but you can hear an ableist remark being made. Even when they know what the law is, the way they interpret the law is so different. And they want to interpret it rightly, but they don't know why a visual impaired student, even though the guidelines say so, why would he need a recorder? So these kind of things, I think it's very important to conduct the sensitization programs, just like we have under POSH. I think if we can have it for disability rights as well, because everyone thinks we know. There's so much of unlearning that needs to be done in this area, that being nice is not really synonymous to treating someone equally. We all think we have done our due by just being nice.
Very quickly, closing remarks, Shampa.
It's difficult to give one line on women with disabilities. When I say that I have
That's unfair.
yeah, it's
intersection.
yeah, it's unfair, and I said that I can, since you have so much experience, then it's difficult to pinpoint which is important and which is not. But I personally feel that. If you think of, like, because Sanchita also talked about POSH, like we have, it's compulsory in every school, college, it is compulsory to have POSH training. People call us, invite us, and the companies invite us that we need to do POSH sensitization. And this is something very important, that we need to include women with disabilities in these dialogues. And it's not like, it's not something, bypass kind of thing. Okay, like it's not a secondary issue. That is something very important to understand. And just last one point I want to make is, because see, in RPD Act it says that every poverty alleviation scheme there will be 5% reservation for women with disabilities. Now it's only, as far as I know, it's only in Tamil Nadu this case was filed, and it was NPRD's Tamil Nadu affiliate who filed the case, and they made it possible. But it makes me sad that we have to fight this case in every single state. That makes life much more difficult for us.
Justice Bansal, closing remarks just in 30 seconds, but I did want to ask you one question on representation in the higher judiciary. Of women, of minorities, and of people with disabilities. Sorry, you are not representative for all.
Just a small comment on what you have put. Anybody who is able to make it, it's actually a competitive base. There is a reservation to make it more inclusive. Anybody who has been able to make it has been given full respect. I don't think they have suffered in their working because of any limitation. Every care has been taken, whether it's a wheelchair. There is one judicial officer who has a difficulty. She cannot even get out. So what happens is, in lunchtime, they shut it. There's somebody to help her. So her dignity is being maintained and taken care of, which is very, very important. Just one line. I've been thinking about it. There is a problem in the definition. Disability and mental health, there is a gap. I know those who are with autism, Downs, they are not covered in disability. While disability gives some kind of leverage, facility, mental health does not. For a parent, for a person, whether it is disability or mental health issue, the disability is the same. But the law is not treating it equally. That is where we need to look into it. Thank you.
Just to end, one is, of course, the RPD Act implementation needs a lot more. Secondly, even the provisions under the RPD Act for women with disabilities are extremely insufficient. They only talk about women with disabilities when it comes to reproductive rights and some medical procedure and social security. So it's highly insufficient. There is a need for a larger recognition of women with disabilities and the discrimination they face. We have many more legislations which still have discriminatory provisions against persons with disabilities, like the marriage laws, which still have unsoundness of mind and all those provisions. What are we leprosy has now been removed by litigation, but you still have other disability related stigmatic references there. So a lot of work, in short, has to be done to address rights of women with disabilities.
Thank you. I'm going to take quick audience questions. Please keep it short. No comments, question only. Do you need a mic? Can you pass this on, please, somebody? Thank you.
So I'm a disabled lawyer and I've been studying this subject for last 37 years. And I don't have a question, I have the answer with me. So if you allow and you give me around 4 to 5 minutes.
No, because we have another session. It's not
Okay,
fair
then
to
I
my
don't want to
next
speak
panel.
because I feel that I'm more qualified than the panel.
Okay, fair enough.
This is a counterpoint, but this
That's
is what
the point of view, but
37 years of studying yields better results than
Yes.
5 minutes of discussion.
All right.
I
Do
don't
we have
want
an
to
actual
answer.
question?
Yeah, I don't want to tell the solution.
That's okay. Do we have an actual question? Did you have a question, sir?
So, ma'am,
Mana.
so women with mental illness or psychosocial disabilities are more vulnerable to sexual violence, and that's a fact. And something that I've been thinking about is the fact that the Mental Health Care Act does provide us with a very comprehensive infrastructure that takes care of treatment, and proper treatment does mitigate a lot of factors that come into play when in instances of sexual violence. For example, someone with bipolar, if they're having a manic episode, they're more likely to encounter I just wanted to ask you, like, what have your experiences been on the ground when it comes to the interplay of treatment? And
Who would like to take the answer? Yeah. Shanta.
What happens generally when such a complaint is lodged, usually the person is not believed. It's just like you're imagining, that's the most common response of, and it starts from police to the judiciary. The lawyers also, very few lawyers will know. I mean, someone who's fighting a criminal case will have very little knowledge about the Mental Health Care Act also. So, I mean, that is the intersection where these problems, I think, it's a lot more. I can send you some of my articles also, because we have filed a lot of cases, and I work mostly with homeless, mentally ill people, women who have faced several kind of sexual assaults, and we fought many cases. So I can send you some, but the whole concept is, the initial thing is you are not sick. Anyway, when a woman complains, it's usually like the patriarchal mindset is like she's imagining, and this, when she's mentally ill, it's like you are imagining. Who will touch you? We even have quotes from police officers and doctors who said, who will touch you? You are disabled. Why should anyone want to have sex with you? Yeah. These are the kind of quotes we actually have.
I'm out. I'm really. One more person. No, I have several hands. So, okay, I can take one more. You guys decide. Toss a coin. Please, sir. Yeah. Yes.
ओके मेरा क्वेश्चन ये है, जैसे पोस्को का आपने बताया कि कॉलेज और यूनिवर्सिटी में वो सेंसिटाइजेशन होता है, पर वुमेन विद डिसेबिलिटीज़ का तो नहीं होता, उसके अंदर वो नहीं बताया जाता। ऐसा पोस्को में क्या है जो RPWD एक्ट 2016 में नहीं है, कि RPWD एक्ट 2016 के अंदर भी तो सेंसिटाइजेशन का मेंशन किया गया है ना, कॉलेज और यूनिवर्सिटी और वर्क प्लेस पे होना चाहिए, पर पोस्को के थ्रू तो हो रहा है कॉलेज और यूनिवर्सिटी के अंदर।
समझ गए। वुड लाइक टू टेक? आप लीजिए।
जो पॉक्सो एक्ट है वो सिर्फ नॉर्मल हेल्दी ह्यूमन बीइंग और कोई भी के लिए सिर्फ सेक्सुअल ऑफेंसेस के लिए टारगेटेड है। वो आपका डिसेबिलिटी पे फोकस नहीं डालता है। व्हेन यू आर अ डिसेबल्ड पर्सन, द एक्ट गिव्स यू लॉट्स ऑफ राइट्स, प्रिविलेजेस, एंटाइटलमेंट्स। तो उसके लिए जो एक हमारे को अवेयरनेस चाहिए वो बहुत ज़्यादा है। पॉक्सो एक पर्टिकुलर एरिया के लिए, डिसेबिलिटी का एरिया बहुत डिफरेंट और बहुत ज़्यादा है।
Also, even the judges are not aware in sexual violence cases against women with disabilities. I've been on the DCW panel for a while. Even the judges handling the cases, the PPs handling the cases didn't know what the law was on the point, didn't know how to record the evidence of such a witness.
Spoken about this. Magistrates not aware of the law and lacking. I'm not cutting you off. It's just that I feel that we have another panel. I want them to have adequate time to explore their issues as well. Thank you very much. It's been an honor. Yes, of course. Thank you. Thank you so much. Had a great time. Yeah, we don't do for that. It's okay. I need please come. Just be careful.
Sarah? May I request all our panelists for the next panel to please come on the stage. Emma, just ask someone that the bottles and all need to be changed. Glasses वगैरह हटा दीजिए जो. Yeah, Achal is there. She's coming. Sarah. Where is Kiran? Oh, okay. You want to? Okay.
We have lunch to hold you up till now, but we also have a very important conversation to have, which has really happened in India's legal discourse, which is to talk about intersectionality of individuals who are disabled and are also queer. An intersectionality which causes too much stigma. An intersectionality which is not even seen within these marginalized communities. A disability rights movement, a cis heterosexual disability rights movement that refuses to acknowledge that there are also people with alternate gender identities and sexual minorities. And also a queer rights movement that refuses to acknowledge that not everyone is able-bodied. in about more than a decade ago, the Punjab and the Haryana High Court in Vibhu Dayal versus the director had said that Article 15 should also include disability as a ground, as a protective ground. And yet here we are. Disability is not explicitly mentioned, even though there's significant amount of constitutional jurisprudence which says that disability is actually a protected ground under Article 15. This is mere constitutional grief. Because we speak to the constitution, we've seen it in CA protests, in gender rights movements, in disability rights movement, and everyone talks about the constitution, speaks to the constitution, reads out the preamble when they feel invisibilized. But here's a community which is stigmatized not just in the sociological sense, but also in the constitution sense. We are here to talk about this constitutional grief and also figure out how can we make space for individuals at this intersection in the constitution, in the society and beyond. Queable is an initiative to foreground the rights of queer persons and persons with disabilities in law and policy who have been long forgotten. Let alone forgotten, actually, they were never counted to begin with. So, in this context, I would request Justice S.K. Kaul, who's very kindly agreed to be a part of this panel and also agreed to launch the website of Queable, which will house resources for queer persons and persons with disabilities, which will have all the legal and policy tools that can help them navigate employers who refuse to provide reasonable accommodation, who refuse to use the right pronouns, in educational institutions who refuse to acknowledge the compounding effect of queerness and disability, and overall social structures, governmental structures that are not built for persons who are queer or who may have any kind of reasonable accommodation needs. Sir, if you could please launch the website.
Good afternoon to all of you. See, we talk about the intersectional issue. Let's understand that persons simply with disability, their acceptance itself has a challenge over a period of time, running into decades. A non-acceptance into key figures or key positions when the disability rights came, it was easier to accommodate them in areas which did not have major decision-making processes. So, in terms of the hierarchical, you always pick them in the lower hierarchical norms. A lot of judicial intervention went over a period of time. We were part of that judicial intervention where many spoke about it. Justice Lokur is here, Sikri, myself, and many others who tried to give some teeth into it. Then you are talking about people with the queer people, different preferences. That assertion of their right still is in progress. And recent developments, at least till I limited office, showed that socially, judicially, governmentally, we had not arrived at a stage where there was acceptance fully. So at least on the first category, there is acceptance at the higher echelon levels now, but still at lower implementation level, there's a problem. Now, when we talk about the intersection of these two, I personally feel it requires a lot of social movement, a lot of discourse, a lot of government initiatives to be able to do that. Because this is problem multiplied by two, in a sense, in terms of acceptance of the existence of these issues and people and what would prevail. I think it's still going to take time to do that movement because sometimes law helps in transacting and transmitting issues which are in the social domain. And sometimes social movements help us in change of law. These are fields where there will have to be a larger role of the law changes if they have to come to, in an Indian society, to bring about a social norm or a social development. But that has been lacking. So this whole debate has been on for quite some time about an anti-discrimination law which is centralized, because one law will talk about one thing, another law will talk about another thing. Something will talk about the queer rights, something else will talk about the person with disability. But if you have a common anti-discrimination law, then that can facilitate in dealing with the issues across the board, and it may help in achieving the objective. While listening to towards the end of the last discussion, there were talks about how um, lawyers don't understand, judges don't understand. Well, like integrity issues. A lot of people talk about judiciary, law, and others, and I tell them, well, they're part of our society. They're not dropped from the top. No special privilege of dropping them from the top rises. So, what is the acceptance? What is the integrity levels? What are the what you think should be the permissible levels in a society are important in constructing even people who come from ultimately land to the post. It's from this pool of talent alone that people will occupy positions. And until the society changes a whole, with little push from the governmental and the legal fields, the changeover takes a little longer. So I'm hoping that some stage, when you hold discussions like these and make some kind of a minutes or some kind of a agenda of this towards the end, forwarding this to the government may help in bringing them and their understanding the problem. If not, there are, I feel, at some level, sensitive bureaucrats. And even if it reaches them, they may be able to propel it to a political stage. Because, see, I believe political stage only gets propelled by votes. Unfortunately, that's part of a democratic setup. That everything is more so today is a vote bank system. This party or the other is not relevant. The issue is what is the vote bank politics in it. But bureaucrats still, though they're bound by the political directives, at times have had education and exposures to different areas which helps them understand. So one of the seminars which you were there last time, I met a couple of bureaucrats from the concerned ministries who were there. And it gave me a positive impact that if the bureaucrats can think like this and do so, their continuous propagating that viewpoint at some stage will have a ministerial impact, even if it takes a little time. Similarly, social movements are built by discussion, conferences, other things. And this is quite visible if you see both the movements, the queer movement, you see the person with disability movement, and how it has traversed over a period of time. It is the acceptance of the social norms also to some extent as the generations come by, which is there. Not that traditional method, no, this is abnormal, how can this happen? Why will this happen, This has to change with the thought process changes which occur. So one hopes that, as time passes by, there'll be more and more interaction amongst the people affected and the people who will understand the policy formulation and help to make it. And this kind of a website, I'm told, is a great initiative, I would say, in times to innovate and help the people who are affected. Thank you.
Thank you. Thank you so much, sir. An individual who's been writing the story of queer rights line by line, starting with privacy and building on in Supriyo. In the last panel that I heard you on, the Keshav Suri and Vidhi panel, you said that hope will not stay silent. And I think that's the takeaway from what you said. Hope triumphs over experience, and it always must. Towards my right is Mr. Kiran Nayak. He is a trans person and a person with disability. He's done significant amount of grassroots work engaged with persons with disabilities and queer persons, and is well aware of the harassment, the sexual violence, the exclusion and invisibilization that is meted out to individuals who lie at this intersection, not just by state, but also sometimes by family members. Kiran, would you like to talk about your experience, your journey? How did you found your grassroots organization? What kind of experiences you've had? And we have stakeholders from the bar and the bench sitting alongside us. What would be your opening remarks if at all you were to start a debate and conversation around queer and disability rights, what would be those 4 or 5 top priorities that you would want people at the bar and the bench to talk about more?
थैंक यू। तो मैं थोड़ा हिंदी में बात करेगा। सो आई एम किरण नायक, आई एम फीमेल टू मेल ट्रांस मैन, बाय बर्थ इज फीमेल and then my identify in age of 12th, so now in 39 cross. So I am working with a trans and disabilities south areas, so especially AP, Telangana, Karnataka and Tamil Nadu and Kerala. So मैं घर के छोट में टाइम में वो टाइम में मन को जेंडर इशू नहीं मालूम है, बट फीलिंग इज देयर. Then slowly every time trans man and क्यूर कम्युनिटीज ज़्यादा लोग के सुसाइड कर सकते हैं. सो मैक्सिमम क्राइसिस, पूरा क्राइसिस इज सुसाइड. फैमिली छोड़ के बाहर, हमारा घर में ऐसा प्रॉब्लम है तो हमारा घर में अभी हमारा पार्टनर से बाहर नहीं आ रहे हैं, तो मेरा फीलिंग बाई बर्थ इज़ फीमेल आर मेल, मेल आर फीमेल. मैं अभी गे हूँ, मैं लेस्बियन हूँ, तो ये ज़्यादा हमारा पास शेयर कर सकता है. तो आई मैरिड इन तिरुपति 2008. तो मैं एक लड़की से साथ शादी किया 2008 में. वो एक बड़ा इशू है वो, तो क्यों तुम एक वुमेन, तुम लड़की है, लड़की को क्यों शादी करे है, तो वो ब्रेकिंग न्यूज़ में थोड़ा छोटा इशू हो है. तो हम सेम मेरा पार्टनर का पेरेंट्स वो केस डालिया. देन पुलिस स्टेशन में क्या बोल रहे हो, तो उधर ही हरासमेंट वर्ड्स स्टार्ट हुआ है. तो ये अभी मेन को हो रहे, बट ज़्यादा लोग बाहर है. सो ये कैसा स्टॉप करना पड़ेगा. ये तो कैसा इश्यूज है रूरल एरिया में, घर छोड़ के बाहर आने के क्या क्या प्रॉब्लम हो सकता है. एंड ओन क्राइसिस 5 years में स्ट्रगल किया. इज़ अ पुलिस स्टेशन, फैमिली एंड सोसाइटी एंड मीडिया, तो कुछ भी लोग नहीं हेल्प नहीं किया. सो स्टार्ट टू इन ऑर्गेनाइजेशन स्टार, सोसाइटी फॉर ट्रांस मैन एक्शंस एंड राइट्स. ओनली ट्रांस मैन इशू काम स्टार्ट किया एंड स्लोली ट्रांस एंड डिजेबिलिटी इशूज़ एंड LGBTQ इशूज स्टार्ट करने टाइम में हम अभी एक वेरी फाइट करने के अभी 1% रिजर्वेशन मैडम जैना कोठारी हेल्प किया कर्नाटका में. एजुकेशन में 1% रिजर्वेशन ला के फुल फाइट किया. सेम टाइम इन तेलंगाना अभी एक पॉलिसी चल रही, तेलंगाना ट्रांसजेंडर पॉलिसी अंदर में ट्रांस एंड कास्ट एंड शेड्यूल कास्ट एंड डिजेबिलिटी इशू क्या क्या हो सकता है, ये दो अंदर लाए. लास्ट 15 years के फाइट करके एक साइड प्रॉब्लम है, एक साइड सॉल्यूशन गवर्नमेंट से कैसा करना पड़ेगा. एंड डिजेबिलिटी, ट्रांस एंड डिजेबिलिटी इशू आ सकता है, बट हमको प्लेटफॉर्म नहीं मिल रहे हैं. अभी मैं ट्रांस इशू बारे में बात कर रहे हैं, तो हम डिजेबिलिटी इशू में बात कर रहे हैं, तो एक ही बात करने के रेडी है. एग्जाम्पल 19995 एक्ट में ओनली टाइप ऑफ डिजेबिलिटी 7 है एंड 2016 में 21 डिजेबिलिटी. सेम अभी ट्रांसजेंडर LGBTQ देखो तो इस छोड़ दिया तो प्लेस छोड़ दिया, हम कौन तो आके जॉइन हो सकता है, पर डिजेबिलिटी में बाउंड्री दे दिया 25 एनफ. सो इन एक्ट अभी पॉलिसी क्या कर रहे हैं एंड जजमेंट कैसा है रूरल एरिया में हासिल जा सकता है. सो अभी एक पॉलिसी में देखो, अभी 2016 PWD एक्ट में है, ट्रांस इश्यूज है नहीं. सेम टाइम 2019 एक्ट में देखो, ट्रांसजेंडर एक्ट में है, डिजेबिलिटी इश्यूज है नहीं. तो हम इंटरसेक्शनलिटी में प्रॉब्लम फेसिंग कर रहे हैं. माइग्रेशन, कास्ट, मैं बंजारा कास्ट शेड्यूल कास्ट में प्रॉब्लम हूँ एंड सेम व्हीलचेयर पर्सन हूँ, सेम ट्रांस एंड डिजेबिलिटी हो. सो इंटरसेक्शनलिटी हम कैसा फेस कर रहे हैं, अभी हमारा एक सवाल में काम चल रहे हैं, बट इज जजमेंट आ रहे हैं, बट कैसा जजमेंट इज कैसा रीच हो रहे पब्लिक में, ये जजमेंट कैसा जा रहे हैं, ये तो हम फेसिंग कर रहे हैं. एंड तो क्या थोड़ा हिंदी में बोल दो क्वेश्चंस, कौन सा रहो तो मैं आंसर कर सकते हैं. तो इंग्लिश आ सकता है, बट परफेक्ट लैंग्वेज इज तेलुगु एक्चुअली. सो हम अभी लैंग्वेज देख सकते हैं, इधर ही अभी लैंग्वेज दे सकते हैं. सो रूरल बैकग्राउंड से लैंग्वेज आल्सो प्रॉब्लम है. सो हमारा काम चल रहे हैं, बट कैसा प्रेजेंटेशन कर सकते हैं. अभी जैना मैडम को हमारा कर्नाटका में एंड एपी तेलंगाना में ज़्यादा सपोर्ट दे रहे हैं, इंडिविजुअल सपोर्ट है. सो ट्रांस एंड डिजेबिलिटी लोग को प्लेटफॉर्म चाहिए. आज मैं आज फर्स्ट टाइम आया मैं ये ऑर्गेनाइजेशन के लिए. मैडम जस्ट मैसेज किया तुम आओ बोले, तो मैं जैसे एंड संभव मैडम आल्सो हमको बाहर है, हम मूवमेंट्स के बाहर है, कैसा आना पड़ेगा, हमको बैकग्राउंड सपोर्ट ज़्यादा चाहिए. सो ये क्राइसिस 2014 में 14 इयर्स गर्ल्स डिजेबिलिटी, मल्टी डिजेबिलिटी, एक विलेज में एक लड़का ऐसा रेप कर दिया. तो वो रेप रेगुलर रेप है, सेक्सुअल पार्टिसिपेंट रेगुलर कर रहे हो. तो 6 मंथ प्रेग्नेंट वो लड़की है, गवर्नमेंट में हॉस्पिटल में आया. वो लड़की 6 मंथ प्रेग्नेंट में डिलीवरी कंपलसरी चाहिए, अबॉर्शन नहीं करना पड़ेगा, गवर्नमेंट हॉस्पिटल में ऐसा बोल दिया. वो फाइट करने के हमको लोकल सपोर्ट नहीं मिल रहा, पुलिस स्टेशन में सपोर्ट नहीं मिल रहा, 2016 एक्ट है वो सपोर्ट नहीं मिल रहा, केस नहीं सपोर्ट नहीं मिल रहा है. वो स्लोली वो केस हम फाइनली 2018 में क्लियर किया. एंड सी प्रेजेंट सी इज 21 ईयर्स एंड अभी बोल रहे हैं मैं तो लेस्बियन बन सकता है. वो लड़की एक्चुअली मल्टी डिजेबिलिटी, वो रेगुलर थिंक किया, मन को हमारा बॉडी पूरा चेंज हो रहे हैं, फीमेल के अट्रैक्शन हो रहे हैं, हमारा जेंडर के बारे में डिफरेंट हो रहे हैं. तो ऐसा हो सकता है समटाइम. सी हरासमेंट इज वन ऑफ द बॉय हो हरासमेंट किया, बट वो लड़की कैसा डिसाइड कर सकता है, पेस कौन दे रहे, जगह कौन दे रहे हैं, वो एक प्रॉब्लम है. एंड मल्टी सम ट्रांस एंड डिजेबिलिटी लोग के लिए बात करने की जगह नहीं है. अभी हमारा एरियाज में रूरल, स्पेशली रूरल में सेक्स सेक्सुअलिटी जेंडर में बात करने की जगह है. वो बात कर सकता है तो घर चो बाहर जाओ, ये क्या बात कर रहे हैं तुम. ये हमारा पूरा एक्सपीरियंस है मैडम. थैंक यू.
बहुत बहुत शुक्रिया किरण जी, आपने अपने एक्सपीरियंस के बारे में बात की. मुझे इस बात का अंदाज़ा है कि कुछ कम्युनिटीज़ इस रूम तक पहुंच ही नहीं पाई और पहुंच ही नहीं पाएंगी अगले कई सालों तक. पर फिर भी मुझे लगता है कि बात करनी ज़रूरी है, क्योंकि आपके बगल में एक रिटायर्ड सुप्रीम कोर्ट जज भी हैं, आपके बगल में एक सीनियर एडवोकेट भी हैं. तो आपने आज इनके सामने अपनी बात रखी, तो धीरे ही सही पर ये मूवमेंट आगे ज़रूर चलेगा.
यस.
Saurabh sir, a pioneer in queer rights in India, an openly gay senior advocate. Could be more, but our systems are such that it stopped somewhere. Sir, as Kiran has also touched upon the idea of stigma and the idea of the idea of stigma. How do you perceive stigma as a person who's navigated a system which was not built for you? And how do you see, can your experience be transported into the rights of the experiences of queer persons and persons with disabilities?
Wow, that's a tough one. I hadn't thought of from that perspective, but it's, yeah. Stigma, I suppose, is the root cause of all prejudice, right? And ultimately, in any anti-discrimination law that we talk about, any form of discrimination, intersectional or otherwise, it really roots down to different forms of stigmatization. And I think we have to see both the unity and the distinction in the idea of stigma. So the fact that you're treated less than another able-bodied, straight individual in the country is one form which is common stigmatization that occurs, for which you can have an anti-discrimination law which will deal with everybody. But there are specific kinds of stigma which are intersectional. To me, intersectionality is not piling on one form of stigma on another. It's not saying that I'll take this and that and together you're much worse off. as a queer disabled person, it is not queerness and disability which are coming together and adding their respective stigmas. What happens is a new kind of stigma is generated. For me, that is what intersectionality is. It's not just a composition or an addition of different stigmas, but creation of a new kind of stigma altogether, which are then not understood within either of the communities you fall within. So a queer disabled person is not really seen as queer or disabled, or what their life is fully understood. So when you deal with that kind of stigma, there has to be certain sensitivity to the uniqueness of the situation of that particular person. But coming to the easier part of your question, which is my personal experience, I suppose. Well, I approach stigma from a cloak of privilege. And I think that's something that maybe we can take Kiran's story and inspiration from. To me, privilege offered me a shield which allowed me to deal a lot with the stigma that I would have otherwise faced. Coupled with that privilege was the arrogance of youth, I think. I started coming out, I came out, I mean, you said, at a young age when I thought everything was possible. And I think that's why revolutions come with the young. When you see the possibility of change and the idea that you can bring change about and you can overcome stigma, that belief that it can happen, it A, empowers you to overcome stigma, B, it forces you not to recognize stigma for what it is also. That is, you just say, it's just people's stupidity and prejudice. Surely I can convert them otherwise. So that is how I came about in trying to change people's lives. But it was not an intentional act on my part. I never set out to change society. I first set out to just try to live. And I think for queer communities, that is often the starting point. Our enemy is not just the fact of stigma from others, but for a lot of us, the stigma comes from within. The refusal to accept yourself, and then therefore being in the closet, and then being seen as a minuscule minority, invisibilized, as you said. So we have to deal with an internal stigma as well. This is not to say that a lot of people with other forms of what would you call stigma, but say disabled people or on the basis of gender, don't also have certain degree of self-loathing and stigma. It happens, but I'm just telling you from my personal experience. And I'll keep it short. That's it.
Thank you. Thank you, sir. My next question is both from the bar and the bench, actually. It's about biases. Now, one of the widely reported conversation that happened between the judiciary and the executive, and I'm taking from Saurabh sir's experience, is that it's a likelihood that he'll be a biased judge if he were to be on the bench. Meaning we shouldn't have women judges because then they will give very gender sensitive judgments. We should not have Muslim judges because then they will give very secular judgments, non-communal judgments. We should not have judges from any minority community because then Dalit judges will give very caste progressive judgments. They will try to implement Article 14 and 15. So this is called, when you're dealing with matters that come up pertaining to any marginalized community, be it violence, be it exclusion from reservations, be it exclusion from employment, educational opportunities, how do you see judges deal with biases? I'm not necessarily talking about you. You're one of the better parts that the Supreme Court has turned out. But we also have other judges who may not be that open to the idea of accommodating, sir. So what do we do as lawyers who stand at the court, at the door of the Supreme Court asking for rights, and we tell you that, okay, we are queer people, we are disabled people, we have a lot of stigma. How do we deal with your bias on the bench?
So if you look at a scenario, it is not necessarily that people who come from a particular disadvantaged situation alone will be able to understand and implement justice required for that section. If you look at the history, there are many empowered, there are judges who have come from privileged situations, there are lawyers coming from privileged situations, who have taken the initiative to endeavor to understand what is the need of the minority group. What is the training of judge supposed to be, or how are you supposed to train yourself as a judge? The idea is to be able to deal with people who may not be like you. And this would be in social thinking, it may be in economic thinking, it can be on persons with special needs, it can be with queer people. So there are many differences which will come, because the human species across cannot be identical. It can be caste, it can be community. Well, you are talking in a society where even if a boy and a girl choose each other, no separate difference. It can be inter-community marriage, even within community marriages. The fact that you make a choice is resented by the society and resented by parents. So when you have the parents, taking lives of children because they think differently, here you're talking about very much greater amount of differences. Even on that minor differences, there is always a problem. So I recollect one of my bureaucrat friends who chose his partner from the same community. So I said, well, this is a very well arranged love marriage. So, but he said, my parents still don't. They said that we didn't find it. We didn't find the spouse. So I'm just giving an example from where these prejudices arise. So the previous generation would think it is their privilege to choose. All these matters come to court. Please understand. Some visible matters may come, but daily matters come where, and sometimes on personal matters, we take them in chambers. And I have dealt with so many issues like these which come forth, where they say, well, you call the father and he says, look, I have other daughters. I mean, if this daughter goes away, how do I deal with it? So the family resentments of how they will be able to deal with other people in the society would certainly more arise from people with special needs and queer than with where there is no difference in that sense. I believe a judge's training is to deal and is supposed to deal with people who are different from him and try to step in. You can never step into the shoes of somebody else. I don't think so. But you can try to step into his area and see how he would feel or what is required for his purposes. We talk about women rights. See, our country at least gave a voting right to women since 1950. You see developed parts of Europe, I think Switzerland gave it in 1970, I said earlier. So there are some social changes which takes time. Some places our country moved earlier. Some places it took us time because of cultural prejudices which existed. We have to accept we are very, very caste divided society. Everything thinks on that line. And within the caste, then there are different factors. Then you have issues. I don't think most of us would think that what if a woman would come, how would the person judge differently? There can be men who are, I think, equally, if not more sensitive to women issues. I, on the lighter side, used to say, see, there are 3 women in my life. I have 2 daughters and a wife. So now can we say that somebody else who doesn't have a daughter only has a son will look at a different way? Because if we start doing in that direction, then making judgments will become a problem. That's why you lay down laws at times. You lay down the parameters of it. The judge, of course, has some discretion, but there is no absolute discretion which occurs. So he is supposed to implement the law. I do appreciate there may be nuances of that which a person may have different. So, and that starts from the lowest court to the highest court. I'm sure Saurabh would agree with this philosophy that you sometimes think, who is the judge? Where do you appear? How is he going to react? As lawyers we used to do this, I'm sure he now does it. That much difference will remain in any society. Does it not happen in the US? Look at the US Supreme Court, how divided the US Supreme Court is, where people say, oh, you are a Republican or a conservative, how you will rule. So that's part of the human species which thinks, lives in different parts of the world, that people will think differently, and as a judge, you are supposed to slowly evolve to be able to think more dispassionately than the others.
Saurabh sir, do you have anything to add to this?
But I'd love to say no and then move on quickly to lunch. I know you. I'm standing between you and lunch, so. But yes, and in terms of litigation strategy, yes, and as to whether I think only someone who is from the community can understand the issues, that's maybe is true, that a non-queer person cannot fully understand exactly the life of what a queer person is. But as Justice Call said, that it is the judicial training which allows a judge to rise to a place where they can empathize and they can understand. You can never truly feel what someone else does. But that's not the job of a judge. You're not supposed to do that. You're supposed to uphold the Constitution and understand that upholding that Constitution requires a certain set of fundamental rights that everybody has, and ensure that everyone gets them. You cannot divvy up a judiciary of say 34 judges where you give a representation to each person on the basis of caste, class, sexuality, gender, religion. That simply won't work because the numbers are small. You do need to appoint judges who are able to elevate themselves from these narrow differences. That's what you hope for. That's what the systems are supposed to put in place, that you appoint such judges. Now, that doesn't happen always, of course. You have, I know Justice Kaul may not have the freedom to say all that he thinks, but I do, given the fact that I'm a lawyer. Surprise, surprise. And the fact is, there are a lot of judges who are hidebound by their prejudices and biases and unable to lift themselves up from it. Those are judges that say have failed us in their job and in the constitutional oath. But for each of those judges, we also have some people who are path breakers. And as Justice Kaul said, this is a reflection of society. Not everyone in society is truly elevated and understands the plight of others. And maybe that's when the burden comes on lawyers as well. Even if a judge is not a person who is truly entitled and enlightened in a particular area of disability or queerness or disadvantage, it is for the bar to teach those judges and argue and bring those cases. I often feel that being a person of a liberal upbringing is also a matter of chance. A chance of which family I was born to, which school I went to, who my peer groups were, who my friends were. And if someone is not liberal, it is my responsibility as not only a lawyer but as a human being to try to convince the person and to engage in a dialogue and try to bring change about. Always believing that change is possible. Which I said I put down to the arrogance of my youth, which has persisted till now. My youth, that is, not the arrogance. So as long as you believe in that which is possible, that you can change the mind of a judge, you have to carry on arguing and hoping, right? There can be no guarantee that I'll get a bench which will have exactly the ability to give me what I want. We saw that recently in the Supriyo case. But that doesn't mean you don't try, and it doesn't mean you don't get something out of it. So biases will remain in judges. Judges are humans. You may call them my lord, but they're still firmly rooted on the earth. And that is the process of building jurisprudence and building cases. You win some cases, you lose some cases. Eventually, as the arc, does it move towards greater freedom? That's the question.
I will just add, somebody who is part of the system, for every, I must acknowledge, every path-making judgment which has come, I could, sitting part of the system, think of a different composition where a complete different result would follow. That is always there. So it is also sometimes, I would say, planned in a way, sometimes incidental in a way, where when you discuss in the corridors, the thinking process would be very different. And that's part of reflection of the society. If the society outside thinks differently, and there are different viewpoints, strongly, today we have strong viewpoints on everything actually. That's part of our society. I think unfortunately we are the middle path and everything is a casualty. Everything is the extreme paths. Then there are bound to be different results to follow from your different development of mind as has happened.
किरण जी, आपका जो ग्रास रूट्स में काम रहा है कर्नाटका के अंदर, उसके बेसिस पे मुझे 2 एस्पेक्ट से आपसे बात करनी थी. पहला है सर्टिफिकेशन का, बोथ एज अ पर्सन विद डिसेबिलिटी, ऑल्सो एज अ ट्रांस पर्सन, एंड सेकेंड इज एक्सेस टू हेल्थ, क्योंकि सबसे मूलभूत अधिकार हैं, और एक विद्या लगा लीजिए, एजुकेशन. तो आपका इन तीनों में क्या एक्सपीरियंस रहा है? आपने कम्युनिटी के साथ बहुत काम किया है, और आपको क्या लगता है कि जो वकील हैं इस कमरे में, ज़्यादातर वकील हैं, जजेस हैं, जर्नलिस्ट हैं, सिविल सोसाइटी एक्टिविस्ट हैं, आपको क्या लगता है कि वो क्या रोल प्ले कर सकते हैं आपके सफ़र को आसान बनाने में?
यस, थैंक यू मैम. सो डॉक्यूमेंटेशन ज़्यादा प्रॉब्लम्स है. जब अभी इंडिया में रहने के मैक्सिमम 20 डॉक्यूमेंट चाहिए. आधार फर्स्ट, देन कास्ट इनकम, डीएल, पूरा एजुकेशन सर्टिफिकेट्स. तो अभी स्पेशल 2 कार्ड है. हमारा आईडी कार्ड, तो ट्रांस है तो ट्रांसजेंडर आईडी कार्ड चाहिए, तुम डिजेबिलिटी हो तो यूडी आईडी कार्ड, यूनिक डिजेबिलिटी आईडी कार्ड चाहिए. सो ट्रांसजेंडर कार्ड चाहिए तो सेम आधार कार्ड कंपलसरी, सेम यूडी आईडी कार्ड चाहिए तो तुम आधार कार्ड कंपलसरी. तो अभी मेरा एक्सपीरियंस, मेरा पर्सनल एक्सपीरियंस, यूडी आईडी कार्ड मन को इजी मिल सकता है, बट ट्रांसजेंडर आईडी कार्ड क्यों नहीं मिल रहे? सो जेंडर इशू आ सकता है. तुम फीमेल और मेल, जेंडर सर्टिफिकेट किधर से है, तुम कंपलसरी एसआरएस हो या नहीं हो, एचआरटी लिए नहीं लिए, तुम ट्रांसजेंडर है नहीं है, तुम किधर से आए, ये इश्यूज डॉक्यूमेंट से नाट है. मेरा टोटल ज़्यादा लोग को ये स्टडी का इश्यूज हो रहे हैं. मैं बीए सेकेंड ईयर के छोड़ दिया, तो ये एक डॉक्यूमेंट इशू से, जेंडर का इशू से एक है. सेम टाइम हमारा जेंडर का बात करने के वो एजुकेशन सिस्टम में सपोर्ट नहीं दे रहे हैं, तो मैं एजुकेशन स्टॉप कर दिया. तो ये एक प्रॉब्लम है. सेम टाइम नॉट ट्रांसजेंडर आईडी कार्ड ले के इतना इजी नहीं है, बट वो 2 लोग के अभी ऑनलाइन में करना पड़ेगा, बट ये तो कंपलसरी है. तो क्यूर मूवमेंट में क्यूर कम्युनिटी को कौन सा कार्ड चाहिए? तो कार्ड नहीं है. ओनली तुम एलजीबीटी क्यू लो, ओनली टी ले लिया, ट्रांस वुमेन, ट्रांस मैन ले लिया, बट क्यूर मूवमेंट लोग किधर जाना पड़ेगा? उधर जेंडर इशू किधर बात करना पड़ेगा? तो ये थोड़ा ये काम करना पड़ेगा. ये काम कर रहे हैं, हम फाइट डाल रहे हैं. तो टका अभी जल्दी जल्दी हो गया. तेलंगाना स्टेट का ट्रांसजेंडर वेलफेयर बोर्ड कमेटी हो गया, कर्नाटका में हो गया, तमिलनाडु में हो गया. तो ये छोड़ के, ये लोग को छोड़ के चल रहे हो. सो ये एक इशू है, ये ध्यान में रख के काम करना पड़ेगा. एंड सम स्टेट ट्रांसजेंडर पॉलिसी है तो ट्रांसजेंडर वेलफेयर बोर्ड नहीं है, बोर्ड है तो वेलफेयर कमिटीज नहीं है, तो हमारा डॉक्यूमेंट्स इजी नहीं मिल रहे हैं, इजी नहीं हो रहे हैं. ये कैसा करना पड़ेगा? अभी इधर लायर है एंड सर है इधर, ये कैसा करना पड़ेगा हमको अभी सजेशन. स्पेशली प्रॉब्लम इन ट्रांस मैन, ट्रांस वुमेन ऑल्सो सेम प्रॉब्लम, क्यूर कम्युनिटी ऑल्सो सेम प्रॉब्लम. ये एजुकेशन सिस्टम में हम कैसा, रिजर्वेशन किधर गया? रिजर्वेशन के हमको सपोर्ट नहीं मिल रहे हैं. सो रिजर्वेशन हमको चाहिए. ये हमारा पर्सनल एक्सपीरियंस है. अभी ये प्रॉब्लम में चल रहे हैं हम. सो डॉक्यूमेंटेशन, अभी रेशन कार्ड, वोटर आईडी कार्ड मन. और एक क्वेश्चन है मेरा, मेरा प्रॉब्लम ये है, तो उनको ऐसा प्रॉब्लम आ सकता है फील्ड में। तुम ट्रांसजेंडर है तो ट्रांसजेंडर पिंचन ले लो, तुम डिजेबिलिटी है तो डिजेबिलिटी पिंचन ले लो, एक ही ले लो। इन इंडियन गवर्नमेंट बोल रहे हैं। सो पिंचन सीज वो क्या, वो डेली मंथली एग्जाम्पल 1000-2000 रुपीज दे सकता है। मेरा क्वेश्चन क्या है, तो तुम्हारा एक्ट इंडियन भारत इंडियन अपना ये सुप्रीम कोर्ट जजमेंट बोल रहे हैं तुम ट्रांस है, तुम डिजेबिलिटी एक्ट है, तुम्हारे पास UDID है, तुम्हारे पास ट्रांसजेंडर ID कार्ड ही है, तो अगेन बोल रहे हैं तुम एक ही ले लो, एक आधार एक पेंशन। सो इधर अमाउंट नॉट इशू, बट हमारा डेटा किधर जा रहा है? हम अभी ट्रांसजेंडर ID में आ सकता है नहीं आ सकता है, आर डिजेबिलिटी काउंटिंग में आ सकता है नहीं आ सकता है? सो ये एक बड़ा क्वेश्चन। एंड सेम स्टेट टू स्टेट कॉस्ट चेंज हो सकता है। एंड तेलंगाना में मैं अभी आदिवासी लंबानी ST एंड कर्नाटक में अभी 17 ईयर से स्टे कर रहे हैं माइग्रेशन से। मन को कैस्ट इनकम चाहिए, मन को ST दे दो बोल रहे हैं, हमारा लैंग्वेज ही डिफरेंट है, शेड्यूल कास्ट दे दो बोल रहे हैं गवर्नमेंट के साथ। नो, हमारा स्टेट में तुम AC है, AC के साथ रहना पड़ेगा। ये एक फाइट चल रहा है अभी। सो दैट इज ओके, स्टेट गवर्नमेंट क्या वो डिसीजन कर सकता है, ओके। बट प्रॉब्लम हम अभी ये प्रॉब्लम मिनिमम प्रॉब्लम से, ये रूरल एरिया में ऐसा ऐसा हो सकता है। डिस्ट्रिक्ट कलेक्टर और स्टेट गवर्नमेंट ये रूल्स कैसा बनाना पड़ेगा, ये कैसा जाना पड़ेगा, ये मोर देन इम्पॉर्टेंट। एंड स्पेशली और एक मैडम नहीं बोली है, बट मेरा ये है एक्सेसिबिलिटी इशू में आ सकता है। तो अब मैं बोलिए मेरा जेंडर तुमको मालूम है, अभी मैं नहीं बोलिए तो एक किरण इज व्हीलचेयर पर्सन, तुम्हारा दिन वो माइंड में हो सकता है। बट ज़्यादा लोग अभी इंडिया में, मेरा पास डेटा है 270 मेंबर ट्रांस एंड डिजेबिलिटी क्यूर कम्युनिटीज लोग हैं, वो लोग को बाहर आने के डर है। क्यों? सेम टाइम वो प्लेटफॉर्म नहीं है, किधर जाके बात करना पड़ेगा, किधर जा सकता है तो क्या नेक्स्ट क्या हो सकता है, हम घर छोड़ सकता है तो किधर जाना पड़ेगा, शेल्टर नहीं है, एजुकेशन के छोड़ के नाम के बाहर आ सकते हो तो हमको शेल्टर नहीं मिल सकता है। सो ये पूरा हमारा ये प्रॉब्लम्स में ये सिस्टम थोड़ा चेंज होना पड़ेगा। अभी डिजेबिलिटी कमिश्नर कर्नाटक स्टेट में डिजेबिलिटी कमिश्नर्स है, बट कितना रीच हुए वो, कितना केस ने सॉल्व किया? कर्नाटक में एक ही केस नहीं सॉल्व हो रहे, पेंडिंग, ऑल केसेस पेंडिंग। कितना केस डालो तो ऑल केसेस पेंडिंग, नॉट ए सक्सेसफुल। सो कितना टाइम चाहिए सर? रियलिटी हमारा प्रॉब्लम है तो हम क्या सोसाइटी का प्रॉब्लम है, क्लाइंट का प्रॉब्लम है, और कौन सा लोग का प्रॉब्लम है, और जजमेंट का प्रॉब्लम है, ये हमको नहीं अंडरस्टैंड ही नहीं हो रहा है। थैंक यू मैम।
Saurabh sir, we won't hold you up for long before lunch. Just in terms of a 30-second concluding remark, what do you think the queer community should do to acknowledge this able-bodied and disabled dichotomy within it?
I think there's a complete hierarchy within the queer community, not only on the question of ableism, but caste, religion, etc. I think the queer community has to start recognizing the fact that someone who can discriminate and inflict disadvantage on the basis of his sexuality or gender identity is also the same kind of person who can discriminate on multiple other grounds. And if you want to change society, then you can't just ask for change for yourself, because that person is not the sort of person who will suddenly be nice to you and be evil to everybody else. So when you fight for your rights, you have to recognize that you have to fight for everybody's rights. And I think that's a message the queer community needs to tell itself and internalize. Stop leaving anyone behind. The L will not leave the G will not leave the B, T, Q, I, or indeed every other form of discrimination, because you have to recognize the humanity in all of us.
And Khalsa, in your opinion, what lies ahead of these two movements? Because you've delivered landmark judgments for both. What do you see the next step for us as lawyers who care about queer concerns and the concerns of the persons with disabilities?
First, I'll give support to what Saurabh said. See, it cannot be that my discrimination is discrimination and your discrimination is not discrimination. Every discrimination carries with itself its own nuances, and that is most important. I've always said things take time. After all, let's look at the issue of decriminalization of the same sex. How many years did it take? How many ups and downs did it take to reach a particular stage? Similarly, same sex marriage reached a stage, did not go through. Persons with special needs, I think the movement over a period of time has helped people. Visual disability has not slowly permitting people in higher fields and important fields to join there. So you have to change, in some extent, you have to change the social thinking process. When within the family, if you find somebody different and you throw him out or exclude him from the family, that itself is the first challenge for the society. And I think the moment will go ahead. I think some laws, I'm hopeful, will change. I also believe judicial thinking will also progress as a little part of the next generation comes, who our thought processes are better. I do believe when I see my children, their thought processes are better than me. That's how I look at it on issues like these. Then they treat their children differently. So as it goes on, when another, I can't say wait for another generation, but what I'm saying is, as time passes and people, the thinking process changes, it will have some impetus to persuade the legal people also to change. And when such people join the judiciary itself, there will be changes in how they reflect on the distinguishing in different aspects.
Thank you. We'll open up the floor for one or two questions because we are a little over time. But please, if you have any questions.
There's something bulgy, we send them to the women jail. As people who have been on both the sides, how do you see the jail reform? That's one intersectionality I'm adding to the whole thing.
If the people change, the jail will change. If the police thinking change, the jail will change. After all, the system of jail reforms means police personnel thinking differently. Is it not so? If it is so, then if others think differently, and with it the police personnel also think differently, it will take place. Of course, one aspect of jail reform is not directly relevant is we have too many people in jail. That's the bottom line. There are people who should not be in jail who are in jail. And we have more under trials in jail than convicted people in jail. So that also creates its own pressures on facilities and pressures on the police how to handle it.
So in Hyderabad Chanchalgoda jail, we are two cases we are attending, but that jail is now providing finally providing special rooms, one room. So transman, transwomen are PWD. Any accessibility also there, only one jail. We are visiting also, so good supporting sir there.
Just to add to it, and there, the time for more questions. Changing the mindset is not terribly easy. You mentioned prison reform. I mean, you still have the two-finger test in matters of rape, which is supposed to be prohibited, but it's still routinely done. It's not just about gender in terms of transgender people. It's about general sensitization, and that reflects back to the question that we were discussing earlier. Discrimination of one form manifests itself in discrimination of other forms as well. So you need to have regular training, I suppose, and also not just the carrots of more training, but the sticks of punishment if there's some violation. Tamil Nadu has done it recently, come out with the set of regulations where their police personnel are required to adhere to a certain norm, and if they do, they will face disciplinary action. So that's what you need to do, because in India, people listen to a danda more than anything else. And maybe it's time the police is put to that danda and saying, if you do this and there's a complaint, then you will have to answer to this. Now, most trans people will be too disempowered to actually act upon that. But who knows, there may be one trans person who does. And that fear is enough of maybe bringing some change about.
Any other question? We can take one more question.
Yeah, Justice Cole, you just gave example of Switzerland and India. Switzerland gave women voting power in 70 and India we got 50. The USA is still waiting for a woman president. We had already. In case of India judiciary, our judges were selected for High Court and Supreme Court being a queer, and because of security reason it has been denied. So how long it will take?
I wish I could give a straight answer, but I gave this answer for women judges at one stage. I said, look, you see the judicial service today, 1/3 of the judges are women. Across the board, and I've been to places like Bihar, etc., where people are, difficult postings to do. They say, okay, why can't they be in High Court and Supreme Court? I said, because to become a High Court judge, somebody had to join the bar 25 years ago to be able to be eligible, because the age profile you take. 10 years hence it will happen. People from women are staying in the profession, have come from national law school. Now, suppose in the legal profession, there were people who are there, things will change. There is at the moment an obstruction, an obvious case of obstruction which we witness, but that's because the government thinking policy and the role it played was such that they felt no. Let me say, somebody told me, no, what you are saying, India is not ready for it. I said, you are not ready for it, India is. That's the reason. So why? That's security reasons. Not security reasons. I don't think that is.
That's an excuse.
That's a. You see, that is because in the MOP they try to insert that position as a ground where they can play a role. This MOP is not supposed to contain that, because the final MOP was sent by the then Chief Justice, which was the final one. So since there is no consent on this, they put this as a way. It's a way of avoiding it.
Thank you. I would end with a caveat that this was just the beginning of the discussion, from inaccessible pride parades to the transported website which doesn't have a audio capture. There are numerous issues which plague this community, but I'm very, very grateful to the three of you to have started this discussion, especially to Justice Sunanda Foundation to have provided backing to this conversation. Website has been launched. Please give a big round of applause to. Thank you. A little bit of self-promotion there, I'm sorry. But thanks a lot for joining us. I would request Sarah, my friend and colleague from Mission Accessibility, and also a newly employed person at QAble now, to please offer the vote of thanks.
Thank you, Anchal. As we draw this powerful day to a close, I just want to say thank you. These conversations must not stop here. They need to continue in law schools, in courtrooms, in bar association meetings, in media rooms, in legislative committees, and in everyday practices. It must become a habit. It must become default, a shared responsibility. Thank you for being here, and I hope you really have a good day ahead.
Thank you. Please join us for lunch.
Oh yes, please join us for lunch.
Saurav sir.
Good to see you.